Hey, what's up, guys? Welcome to Mute-splaining the interwebs. I'm your host, Burn, Nick Rekieta of Rekieta Law. Streamlabs is trying to silence my free speech. Anyway, what I was saying before I was so rudely interrupted by the gods of volume. Hold on. I gotta change this thing. Thing's gonna tick me off. Okay. Got some stuff to cover today. A bunch of stuff was filed in Victor Mignogna versus Funimation Productions LLC. I would imagine we will see more stuff pop up tomorrow on Research Texas. But today, we have 3 items to cover. One is very short. It is a letter to the court from the law firm of Martinez and Sue, which is the law firm of An Lee Sue, who was brought in earlier on in the case, if you'll remember, was at the TCPA hearing, etc. There is another attorney who is a part of that law firm who is also on the case. But I want to clarify right away, and I'll remind people as we get to the document. But I want to clarify that is not a new law firm or new representation. It is additional representation that is being brought in to assist. So I want to be clear that Vic has not changed counsel. He has added counsel. Some people might be curious about that. So there you go. There's your answer. Come on. Don't be annoying. So we have a letter from Martinez Sue. We have the plaintiff's response. The plaintiff's response to Lemoine's petition to breathe garglingly at Chris Slatosh in a closed room and leer at him with a horrific pedophilic stare. That will be that they are contesting that. And in addition to that, they are pushing for sanctions. They are pushing for sanctions against Lemoine for filing what they are calling a frivolous deposition exercise for the purposes of harassment and undue delay and raising the bill and all of that stuff. So we will go through that. And then the other document that we have is Funimation's request for reasonable attorney's fees, costs, and sanctions. And we will go through, we're going to go through the document. We may skim some of the exhibits. Some of the exhibits you don't need to go through because you were here for one of them. Transcripted the show, which is great. A little disingenuous in how the transcript or how the show is presented. So we'll talk about that when we get to it as well. But those are the 3 major documents that we'll be covering. I had hinted that today I might have Q on to discuss Michael Drejka. If you don't remember Michael Drejka, he was a gentleman, if we could call him that. He was a guy down in Florida who seemed to take it upon himself to police a particular handicap spot at a particular convenience store that he frequented. And in his pursuit of making sure people knew that they were parked in a handicap spot illegally, he illegally parked, exited his vehicle, initiated a confrontation. During the confrontation, he was sort of blindsided and struck to the ground by a man, I think his name is Marquise, something like that. Was Marquise? He's no longer with us in this mortal realm. After he was struck down, he drew his firearm. He was a concealed carry holder down in Florida. He drew his firearm, pointed it at his attacker. His attacker stepped away This is an important step. He stepped away from him and was then shot. Who then ran back into the convenience store and died in front of his young son. So that was nice. Jolly times all around for everyone in that situation. So that was back in 2018, and there was a big hubbub over it because the sheriff of Pinellas County, where this took place, refused to arrest Michael Drejka, saying, well, stand your ground, man, I can't arrest him. This is curious because the sheriff of Pinellas County is notoriously anti-Second Amendment and pro-gun control. So he made a public statement about his lack of arrest was a public statement about stand your ground in a case that was highly controversial, had, of course, the racial overtones, which I personally don't think race had anything to do with this scenario. Whether or not it did is something that's open for your own thoughts. But when I look at this scenario, I don't see any particular animus Drejka had towards black people or this particular black guy or anything like that. And we have lots of stories about how he approached everybody in this way. It's not that this guy was black that he shot him, right? Like, let's get that out there. I don't think that's a thing. It wasn't in the court findings, and it doesn't seem supported by any sort of evidence. But it was a narrative that was going on. So because a white person shot a black person, especially in 2018, it got immediately a lot of attention. And the sheriff used it to make a political statement, which was disingenuous and detrimental. And that sheriff should be punched in the nutsack in the afterlife. Not in the present life. I'm not calling for that. That would be disgusting. But in the afterlife, he should get a lot of groinies, so to speak, with like a mailed fist for doing that, for making his political statement in a highly charged, very controversial case. But Drejka was arrested eventually, 25 days later, I believe, and then charged with manslaughter. And just last month, he was convicted and found guilty and sentenced to 20 years in prison. So I had teased talking about that, and I just talked a lot about it, but we're going to do a full show on it with video clips and everything. I was teased talking about that today with Q, but with these filings, which when I was teasing it, I was forgetting that today there would be filings. With these filings, we're going to push that back until Thursday. Okay, so that'll be on Thursday. It'll be, like I said, a full show. We'll have video clips. I'm going to try and get video clips of the shooting. We'll get, which is not graphic or gory or anything like that. There will be video clips of his police interview that follows, and video clips from the sentencing hearing, which all of them are fascinating, and they show you they're really good illustration of what not to do following what you believe is a justifiable shooting. Because first of all, I don't think it was justified. Looking at it, it's hard to think it was based on all of the circumstances that were involved. But even if you think it was justified, which is fine, you can come to a different conclusion than I do. That's okay in this world. But even if you think it was justified, what we can all agree on for sure is the mistakes that he made following and conducting his legal defense, because they are egregious mistakes. So I figure we could go through that. It's a cool real world example. I have access to, I think, all of the video we need to really make a good case as to what went wrong with his legal defense, and how, if you guys are concealed carry holders, how you guys can avoid those mistakes should you ever be in that horrific situation of having to draw your gun and fire on someone. That will be Thursday, barring some alternate reality where things happen. I mean, which is always possible, but barring something, that should be Thursday with Q. And I'm going to start on the documents in a minute, but I am, this is the beginning of the week and some stuff has happened, I guess, that I got to cover. I got to talk about before we really get into it. This show will be brought to you by Ridge Wallet. Eventually we'll do a spot in the middle of the show. I got a new Ridge wallet and a Ridge knife in their carbon steel finish. They're light. They're really cool things. So I'll show you those. We'll cover that somewhere in the middle of the show. But the other thing that happened to me just today, this is cool, I think, is I'm a Twitch partner now. So I'm a verified thought, which is great. I don't know, like, the cool... I applied for Twitch partnership a while back, and they said no. And I was like, all right, you guys invited me to apply, so I didn't know what happened, but they said no. And then I applied again just a couple weeks back and got notified today that I was approved for Twitch partner status, which is, I've been reading that it's like a hard thing to get, so I'm kind of happy. But I will announce now that should anything happen, a la Medicare or some other thing, should this channel have some sort of issue, I will move the streams from here to Twitch. Just that's what I'll have to do. If there's like a temporary lockdown on the account, or I get some sort of weird community guideline strike or something during the appeal, all the streaming will move to Twitch. So this is definitely not me finding some clever way to get you all to follow me on Twitch. I'm just kidding. It absolutely is. It absolutely is. You can find the link in the description. You can go follow me on Twitch, but you never have to watch or anything. That content on Twitch is vastly different than here. It's geared towards Twitch. And I'm probably going to be expanding that content to be, I've been wanting to do like a media channel where I do stuff that doesn't involve law. Like, I don't know, movie reviews, book reviews, stuff like that. Whatever's interesting to me that people might want to talk about will be on Twitch rather than here. So we can maintain the integrity, whatever integrity there is of this show and the purpose of this channel without diluting that down, but still getting to produce other types of content that I'm interested in. So if you want to do that, or if you want to just have a ready access to the backup, it's twitch.tv/Rekieta Law. Very simple. You can go over there and follow. Like I said, you never have to watch it if you don't want to, but if you want to just be prepared, it's there. It's there. So that being said, should we get into these documents? I think we should do some chats and get into the documents. Oh boy. But yes, yes, I did hear that Medicare has been fully demonetized over on YouTube. Seems he was reusing content, which is interesting because my understanding is he doesn't have any videos on that channel. And I've seen Jim stream, and I've never seen him present content without commentary. Now, I haven't watched all of his streams. I can't verify everything, but I have never seen Jim not provide chuckles to the content. That's wild. So, we'll see. We'll see. My high hopes to Jim that everything gets fixed and cleared up with YouTube. And I know he doesn't need my help or anything, but if there's anything I can do, of course, he's welcome to come here or whatever, or do whatever. If I can assist, happy to do so, because that's absolutely ridiculous. So that being said, let's hit these chats. Let's then hit these documents. So the Pie Baker says, Lemoine voice. No, don't grift me. No, stop. This money was put aside to renew my subscription to a shitty anime dubbing studio. No, stop. No means no. You don't stop grifting me. I'm going to hire Ty to sue you. Hashtag believe victims. Pound me too. So there you go. That's from the Pie Baker. Thank you very much, the Pie Baker. James Ridge says, have you been paying attention to the General Flynn case at all? Oh, it's on the periphery of my attention, but no, not largely. The last several filings have been effing bananas. As an anti-government abuse guy, I think you'll really like this case. Technofrog on Twitter is a good account to use to get up to speed. Twitter. I remember having a Twitter. Last time I had a Twitter, it was just months ago. I was sitting in a park on a bench. That's when the thought police came up and told me to move along. I couldn't add my likes and retweets here. I said, no, I have the same right to be here as everybody else. And they said, no, you don't. Your thoughts are not our thoughts. And if it's not our thoughts, then you don't get to be on this bench. You don't get to be in this park. You don't get access to the public square. So, there was that. Random Blaze says, let's say it together. Oh, hi, Mark. Therese, legally a cat daddy. Welcome to the stream. Are you also going to condense the super chat question and answer down to more victim blaming / shaming like Mark Whipple does for rage clicks? Well, Mark should do it for better rage clicks. He doesn't get very many. Nick Surge, thank you for the donation. Based Knopfler says, g'day, Nick. That is actually Australian. Thank you. Just thought I'd let you and Lady Rackets know that my house wasn't raped, my dog wasn't burned, and I didn't have to put myself down because of cancer. Things have gotten a bit better. Sincerely, a filthy 3/4 Nick. Oh man, I am glad that my promise of a better day turned out to be true, because I would have felt really terrible if it had gotten worse. So thank you. Oh yes, and Dominique Sky has apparently been banned off of Twitter even harder than I was, which is kind of funny. And by kind of funny, I mean it's very funny. I can't think of a more deserving pile of garbage than Dominique Sky. Oh, jeez. Whew. Oh my gosh. I'm going to pour some bourbon. What should we start with? What should we do? Oh God. I always forget this bourbon sucks. Oh my goodness. Oh, and it is a new month, so there will be there's supposed to be 2 Cooking with Ragged streams last month. I was only able to get 1 done. There will be 2 this month. I'll probably do a Thanksgiving prep special, which will not be on Thanksgiving, but before Thanksgiving. In case you need to know how to cook a turkey, I figure I'd cook a turkey because I love turkey. That'd be like a 4-hour cooking stream. You can only get access to the cooking streams by being a Patreon or New Project 2 subscriber, although I hear New Project 2 is having issues right now. As soon as I find out when those issues are resolved, I will let people know. But yeah, the streams are kind of fun. In them, I almost burn my house down. I make and mispronounce all sorts of food. I do cooking techniques that people don't like. All sorts of stuff. It's a fun time. It's very intimate because it's just people from the Discord. It's just subscribers. So the audience is lower, and lower numbers or whatever. And it's a little more interactive. And there's no super chats in them. So, there's that. But yeah, so if you're interested in that, sign up for the Patreon, the New Project 2, or whatever. But there will be 2 this month. One will be maybe even this week. I want to do it as soon as possible so I can get both of them in. That being said, Mithrin Emmer says, leave Lemon Boy alone. He just needs Slatosh to direct him to all the con sluts. Oh, and get his hand on that GoFundMe cash since Moronica can't pay him. I've got bad news on the GoFundMe cash. He's not going to get it. Ryan Mercado says, Nikki, where's the money? The chat is waiting for their share of the GoFundMe. I have sent all of you the GoFundMe money and you know it. I want my share in a suitcase of cash. Well, it's distributed across all of you. It would be rather small. It wouldn't be like, it'd be like a pocketbook or whatever. I do know how to make roux. Keck, I'm going to make a roux. You know what? I made mac and cheese with a bechamel yesterday. So you shut your mouth. That starts with a roux. Bechamel. Sorry, bechamel. Stupid French. No one likes the French. Okay, let's get into these documents. What should we start with? Should we start with Funimation? Well, let's start with the letter. Let's start with the letter. Let's go in reverse order. We'll do Funimation last, I think. How's that? My roux is great. How dare you? How dare you? Hold on, let me center that bad boy a little bit. Guys, my mom is from Louisiana. I know how to make a roux. I know how to make a roux. Okay. Roderick, you're the good French. I'm part French too. It's not like I get the French pass. I get the baguette pass. Listen here, you stupid baguette. Okay. This is Martinez Sue, a professional corporation. We've got Michael Martinez, Anli Sue, and Jason Blatt are listed on the document here. This is okay. So this is a letter to the Honorable Judge Chup. Currently, defendant's motion to compel deposition and documents of Chris Slatosh is scheduled to be considered by the court on November 7th, 2019 by submission only. Tarrant County Local Rules for Civil Actions provides, quote, by agreement, parties may submit matters for ruling by the judge without a personal appearance and oral presentation. The judge should be advised in writing when such a procedure is desired. Wait a minute. Did Lemoine lie? Or lie by omission? Or break the rules? Why? He's an unethical pile of garbage, right? We're starting to notice and see this come through more and more as this goes on. Lemoine didn't follow the rules. He set up a hearing by submission only without having buy-in from counsel. He asked the court in writing for that hearing. He noticed the hearing, which would imply that he had the agreement of the other party. He did not. So, what is that? So yeah, there you go. Plaintiff does not agree with defendant's desire to submit these matters to the court without a personal appearance and oral presentation. Plaintiff hereby requests the court to cancel the hearing by submission and, if defendants request their motion to be considered, to schedule the hearing with a personal appearance and oral presentation. So, yeah, that's the letter. This is a very short and sweet letter. Canceling the hearing. Well, requesting the court to cancel the hearing. You know, if of course the court decides not to pull the hearing down, I assume someone will be at the courthouse on that day to address it, but who knows? Who knows? We'll have to see. But you know, that's how this fight is going, which brings me to the next document. This is the plaintiff's response to defendant's motion to compel deposition and documents of Chris Slatosh, First Amendment motion to quash, and motion for sanctions. Whoa! Look at those bagged, look at those bagged ass clothes. Bag. My son's a bag. Pro Hero All Might, don't do that to me. Goodness gracious. Okay. So this is a response to all of the production requests from documents and himself of Christopher Slatosh. So now comes plaintiff Victor Mignogna and files his plaintiff's response to defendant's motion to compel deposition and documents of Chris Slatosh, First Amendment motion to quash, and motion for sanctions. Asking this honorable court to deny defendant's motion to compel deposition documents of Chris Slatosh, quash defendant's notice of intent to subpoena Christopher Slatosh, and award sanctions to plaintiff in connection therewith. In support thereof, plaintiff would respectfully show the following. I think maybe plaintiff's counsel is getting tired of the garbage. I think just maybe there's some frustration with the way that the defense has conducted themselves during this nonsense, and that seems to be playing out. And it looks like they're trying to go ahead and fire back a little bit. And let's see the basis for it. You think Ryan Sellers doesn't like Lemoine? Did you get that impression? I may have gotten the same impression. Plaintiff asks the honorable court to quash defendant's notice of intent to subpoena Christopher Slatosh, which seeks the deposition of non-party Chris Slatosh. Plaintiff seeks to quash the deposition on the grounds that the discovery is sought in clear violation of sections 27.003C of Texas Civil Practice and Remedies Code, which suspends all discovery until the court has ruled on a motion to dismiss. Now, this is, of course, an interesting approach to the argument, because they're suggesting that the motion to dismiss is not fully disposed of yet, which is, of course, contrary to the idea of filing the appeal. However, as a reminder, the rule of Texas appellate procedure is that if an appeal is filed early, it is perfected at the time when it would need to be filed. That's how it goes. Oh, and I am told that the appeal was perfected today. So if I get to see those documents tomorrow, we may go through those tomorrow. But so there's you have to file the initial notice of appeal, and then you have to file some other stuff with the appeals court before the appeal is perfected. And that due date was today. I'm told they were filed today. I haven't actually looked to see if they were filed, but and to see if I have access to them or anything like that. But I will attempt to grab those papers for a show tomorrow or Wednesday, depending on what we get to over the next couple days. But yeah, we'll see what's in their actual appeal. However, it's important to note that in law, you are allowed to argue in the alternative. There isn't necessarily a problem with arguing both positions. And importantly, again, there is a rule of appellate procedure which says that if it is early, it's just counted as if it was filed on the date when it could be otherwise filed. So there's not really harm in filing early. Most of the case law around filing early, where the appeals are dismissed, first of all, that dismissal would allow you to appeal again later, and second of all, they're those dismissals occur when there are other outstanding issues in the case beyond something like sanctions and fees, which should be disposed of within a relatively short order. So, but that said, let's see how this argument unfolds. In addition to the grounds asserted above, the deposition sought is not relevant to a determination of whether plaintiff's action, quote, was brought to deter or prevent the moving party from exercising constitutional rights and is brought for an improper purpose, including to harass or to cause unnecessary delay or increase the cost of litigation. A matter already decided by this court. Further, the deposition sought is not relevant to plaintiff's and his counsel's culpability in bringing and prosecuting the dismissed claims. Specifically, the testimony at issue was offered as a declaration in response to a defendant's motion to dismiss. So yeah, what they're saying here is that the subject matter of the testimony for which they're trying to use to get the deposition, the subject matter of Slatosh's testimony is in response to the motion to dismiss and has nothing to do with whether or not Vic brought suit appropriately, or is or whether or not it was prosecuted appropriately. That has nothing to do with that. It was merely a statement of facts about the about what happened, and it doesn't have anything to do with the sanctions motion that's at hand. Plaintiff asks the court to deny defendant's motion to compel deposition and documents of Chris Slatosh. Plaintiff further asks the court to award plaintiff sanctions pursuant to Rules 13 and 215 of the Texas Rules of Civil Procedure and Chapter 10 of the Texas Civil Practice and Remedies Code on the grounds that defendant's motion to compel deposition and documents of Chris Slatosh, on the grounds that defendant's motion is frivolous, has no basis in fact, law or fact, and because defendants have unnecessarily caused plaintiff to incur costs and attorney's fees in responding to the baseless motion. Also, because defendant's lawyer is a giant cuckbag. I think that's written in there somewhere. Maybe it's in a footnote. Background. Plaintiff initiated this proceeding seeking relief from defendants on the basis that defendants committed torts against plaintiff based on defamation, TI with prospective business relations, civil conspiracy, and vicarious liability. Defendants responded seeking dismissal pursuant to Chapter 27. In his order dated of the Civil Practice and Remedies Code, also known as TCPA, in its order dated October 4th, 2019, the court granted defendant's motion to dismiss in full, stating therein that the court grants TCPA motions. Plaintiff Victor Mignana's claims against defendants Funimation, Marquis Real, and Toye are thus dismissed with prejudice. On October 23rd, defendants served plaintiff with their notice of intent to subpoena Christopher Slatosh, seeking deposition and production of documents from the same. At the time of the serving the notice, the court had made no finding of good cause for defendants to seek such discovery, nor had the court signed any order to allow specified and limited discovery relevant to the motion to dismiss. Arguments and authorities. Hold on. I'm trying not to yawn. I have been exhausted the past 2 days. So. Use your telepathy. Hope you guys got that message. Let me telepath you a message about someone. Yes. I hope you got that. The pivotal question is whether defendants were permitted at the time of serving their notice of intent to subpoena Christopher Slatosh to seek said discovery. The answer to this question is no. Defendants are not allowed discovery absent a court order. Section 27.003C of Texas Civil Practice and Remedies Code provides in relevant part, except as provided by Section 27.006B. On the filing of a motion under this section, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss. The exception reference, Section 27.006C, provides, on a motion by a party or on the court's own motion on a showing of good cause, the court may allow specified and limited discovery relevant to the motion. Roderick, you got some of that message right. While the court has granted defendant's motion to dismiss in full, the court retain jurisdiction so that the defendants may submit evidence and briefing in support of an award of attorney's fees, costs, and other expenses incurred in defending the action, and an appropriate sanctions pursuant to the Texas Civil Practice and Remedies Code 27.009. By the language of the order, the court has not made a final ruling on defendant's motion to dismiss because it must determine an appropriate award. Under TCPRC 27003C and 27006B, defendants are required to seek permission from the court prior to seeking any discovery. Pursuant to such request, defendants must then obtain a finding of good cause in order to seek any discovery. Further, the order from the court would only allow specified and limited discovery relevant to the motion. In this case, the defendants failed to seek an order from the court allowing for discovery, and thus defendants had no authority to seek the deposition of Christopher Slatosh at the time of filing their notice of intent, nor do defendants have the authority to request the court compel said deposition at this time. So they're flat out laying out their theory that that under the TCPA, discovery is still stayed in this action, and they have to request additional discovery. They have to request permission to conduct additional discovery. They haven't done that, and the court hasn't on its own decided to grant additional discovery, even without a defense request. So this is, this is their argument. I'm not actually sure that that's the strongest argument they could make, that it's, that the TCPA has stayed discovery. I think they're outside of any discovery period at all. Even if they're outside of the TCPA, I believe they're outside of the discovery period, which is up to 30 days before a trial. Since there will be no trial, the discovery period is necessarily over at the hearing. By the way, remember how we're trying to compare whether or not, the TCPA hearing is a trial for the purposes of Rule 63. Well, considering you're allowed to conduct discovery within 30 days of a TCPA hearing, I guess the discovery stayed at that point. So I guess that would be an unanswered question then. Curious. Either way, if it's a trial, no discovery within 30 days. So I guess scratch that. My brain got ahead of my mouth. Our community is the best community. Listen, we have to do some things to heal the community. We have to heal the community. It's all of our jobs to heal the community now. A community torn asunder by liars, but they're good people. Very good people who are liars, who have lied about someone to destroy them. They're good people, though. Got to heal the community, right? Right? It's going to heal. It's going to heal. If we all just shut up about it, it'll just heal. Now go away, you baggots. The discovery sought is irrelevant to the issues currently before the courts. Even assuming the defendants had authority to seek discovery, the discovery sought by defendants is irrelevant to the issues currently before the court. Specifically, the only issues remaining before the court are related to attorney's fees, costs, and the amount of sanctions, quote, sufficient to deter the party who brought the legal action from bringing similar legal actions described in this chapter. Because the court has already ruled on defendant's TCPA motion, no good cause exists for conducting the deposition of non-party Christopher Slatosh regarding any issues related to the defendant's TCPA motion. Put another way, because his testimony is not relevant to the only remaining fact of consequence in this action, defendants have no need to conduct Slatosh's deposition. This is a good argument. This is a very good argument. There's no purpose to bring in Slatosh. Now, I know very, very smart Cupid dolls like Dunford out there will sit and stroke themselves over the idea that Slatosh somehow has any sort of information about the start of the lawsuit. And this is logically unsound thinking by the opposition, right? The idea that Chris Slatosh, who they assert was threatened legally to bring Vic back to Kamehacon after canceling him and causing damage to him, to assert that that theory runs in the same vein as Chris Slatosh having information relevant to why not the suit was brought and whether or not it was frivolous is nonsensical, right? If Slatosh ghosted Vic and was part of the reason that the suit was brought because of the damage he suffered being canceled by Chris Slatosh due to the tortious interference and defamatory statements of the other parties. If that's the case, then he's probably not involved in the legal decision making on whether or not a suit should be brought and wouldn't have any information relevant to the bringing of said suit. So they wouldn't be able to use his testimony to somehow determine whether or not the suit was brought in good faith or whether or not the suit would have what the sufficient deterrent would be for bringing a subsequent suit against similarly situated parties. So good job, I guess. But yeah, so this is, of course, they're putting the other party in a position of explaining how these are logically consistent, how having this deposition matters at all to the remaining question. It's a tough answer. Here we go. Defendants' own pleadings establish the frivolousness of this request. First, defendants argue, without providing any foundation for their baseless allegation, that Mr. Slatosh's testimony will be that, quote, he was threatened with a lawsuit following his decision to retract plaintiff's invitation to Kamehacon, that he was threatened with exposure of his personal information by plaintiff's agents and or individuals who plaintiff was aware were operating on his behalf, and prior to this lawsuit, Slatosh did not believe that either of the moving defendants interfered with plaintiff's contact. Mr. Slatosh will also testify concerning the conduct of plaintiff, his counsel, and his agents throughout the litigation, up to and including the allegedly fraudulent affidavit. Defendants assert that Mr. Slatosh's testimony on these subjects is relevant to the alleged culpability of plaintiff in bringing this legal action. Taking these arguments in turn and considering each individually, it is clear that the subjects identified by defendants for Mr. Slatosh's testimony are not relevant to the determination of what amount of sanctions is sufficient. It is not disputed that Mr. Slatosh breached his contract with plaintiff for retracting his invitation to plaintiff to attend Kamehacon. Chup! Hey, Chup! It's not disputed that he breached his contract. It is not disputed. It is also not disputed that Mr. Slatosh re-invited plaintiff to attend the convention and plaintiff did so. Whether in the interim plaintiff threatened legal action against Mr. Slatosh for breach of contract is not relevant to the plaintiff's purpose or alleged culpability in bringing this suit. So, yeah, you don't get to say that that there's something to the plaintiff threatening legal action against the other party for a breach of contract. A breach of contract that's admitted by both parties is not contested by anybody except for Chup's brain, which I guess maybe there's somewhere where Chup said, I don't believe this or whatever, like in stuff. But yeah, okay. Defendants allege that Mr. Slatosh will offer testimony about plaintiff's conduct in this litigation, quote, up to and including the allegedly fraudulent affidavit. It is not the case, nor is it alleged, that plaintiff procured Mr. Slatosh's affidavit by threat or that plaintiff asked Mr. Slatosh to lie in his affidavit. They try to hint at it, but it's not actually stated, because if they stated that, they would look like real giant cockbags. And yeah, this might be forcing them to state it openly. Go ahead and state it without evidence. That'll go well for you. The statements in Mr. Slatosh's affidavit were made under oath and, in relevant part, are not even in dispute. Summarily, Mr. Slatosh's affidavit states that Mr. Slatosh withdrew plaintiff's invitation to Kamehacon because defendants asked him to rescind. Notice what this is doing here. Hey, Chup, you idiot. This is clear TI. This is clear defamation and TI to cause damage. Just a reminder to all that. Let's see. Asked him to rescind said invitation on the grounds that plaintiff committed sexual misconduct. It is well known and established that defendants were making such accusations publicly and that for a period of time, Mr. Slatosh did rescind plaintiff's invitation. Defendants offer no evidence, by affidavit or otherwise, that Mr. Slatosh's testimony at deposition would be inconsistent in any way with the statements in his affidavit. It is also irrelevant whether Mr. Slatosh, quote, did not believe that either of the moving defendants interfered with plaintiff's contract. Any inquiry on Mr. Slatosh's belief would call for Mr. Slatosh's legal conclusions and would not be competent evidence in determining any facts of consequence remaining in this legal proceeding. Yeah, Slatosh is not qualified to determine if they intentionally interfered with the contract. That's a judge or jury question. Typically a jury. Further, Chup, that's a jury question. Further, in the court's order granting defendant's motion to dismiss, the court expressly stated that the court did not consider Mr. Slatosh's affidavit in its determination. The court's determination was based on its conclusion that the supporting evidence offered was not properly brought before the court for failure to follow technical rules regarding the time for presentation of evidence and the requirements for admissibility of supporting affidavits. Allowing the defendants to depose affiants whose testimony was not even considered by this court would serve no purpose. None of the alleged arguments for taking Mr. Slatosh's deposition would have any bearing on the court's determination of attorney's fees, costs, and/or sanctions. As such, plaintiff can think of no reason other than to frivolously drive up attorney's fees for defendants to seek such discovery. Again, I mentioned this a little while back. What Lemoine is trying to do, Lemoine is trying to take the statutorily imposed sanction under the TCPA. And you can see this in his citation to Landry's, which cites to Lowe. He's trying to turn that into an overall sanction for bad conduct. He's trying to slide in some extra sanctions without having extra sanctionable behavior be a finding of the court, right? So he's trying to say, well, this affidavit was brought improperly and he needs a sanction for that, without actually accusing the affidavit of being improper enough to warrant sanction. Lemoine could file a motion for sanctions based on the affidavits. He kind of tried at the hearing and got ignored. The whole argument was ignored. The judge says, I don't want to deal with this, right? So now Lemoine is trying to somehow get to additional sanctions because he knows there's no way the court is going to add a massive amount of sanctions based on what has happened here. And we'll get to that when we get to Funimation when and their sanctions request and take a look at that. He's not, whatever Volney is, he makes a relatively reasonable sanctions request, one the court might actually impose. Lemoine is trying to blur the water of the existing order for sanctions, which is based on bringing the TCPA in and of itself. He's trying to get additional things considered for the purposes of sanction by the court. That's what he's trying to do. It's a shot, I guess. It's a shot. Accordingly, for the reasons stated and outlined here, plaintiff asks the court to deny defendant's motion to compel deposition documents of Chris Slatosh and to grant plaintiff's motion to quash. Next, Siren Jag. Siren Jag. Is my... Oh, it's the webcam. I hate the autofocus. That webcam is a big pile of baguettes. Whew. Has your mother ever called you Führer? He should have said no, but your mom calls me daddy all the time. God, that would have been funny. Sorry, I gotta wash out that rancid America bourbon. Remember Lemoine spelled with a silent cuckbag in it. Siren Jack says, Nick, how big a problem is it going to be that from point 15 forward they keep calling Slatosh's statement an affidavit and not an unsworn declaration? It's not a problem at all because Lemoine's whining about the affidavits. See, what Lemoine wants to do is he wants the affidavit's defective notary to be an issue in the sanction. That's part of his plan. He's not stating it outright, but he wants to bring that in. He wants, why do you think he ultimately wants to depose Slatosh? He wants to hear from Slatosh. This is what he wants to hear. He wants to hear that Ty threatened him with a lawsuit, threatened to dox him, I guess, or threatened him with, somebody's going to dox you, blah, 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 which I would be shocked to find out that happened. But first of all, I 100% believe Slatosh was probably threatened with a lawsuit. I think he might have even said so in his affidavit that initially there was talks of bringing a lawsuit for breach of contract. That's not a threat that's actionable as long as the person credibly intended to bring the lawsuit, right? And lo and behold, the threat of the lawsuit produced a settlement that reinstated or created a new contract, right? It remedied the breach of contract in some fashion by the party under new material terms. It's definitely a different contract. There was definitely a breach and all of that. To all of the weirdo idiots out there who are saying it's the same thing, and that includes Chup, it clearly was not the same contract. There was damage involved. There were changing of material terms. It makes it a new agreement. But either way, that happened. A lawsuit was threatened, and that would be a reasonable, credible lawsuit, right? You breached contract with me. I'm going to sue to either force performance or get compensation for the lack of performance. One of those things. They reached a settlement. So I'm pretty sure that a threat of a lawsuit was at least on the table. If not, it seems to be indicated in Slatosh's affidavit that a threat of a lawsuit was somewhere. And so if that's the case, then there's nothing wrong with that. Nothing at all. But what Lemoine further wants is Slatosh to somehow say that Ty threatened him to the point of producing a lie in his affidavit. Because they said they expect that he perjured himself or whatever. But so they're trying to suggest that Ty threatened Slatosh to do this, I guess. Which, again, I would be very shocked if there was something that said he threatened Slatosh to produce the affidavit, or that he threatened doxing or some other revealing of personal information to produce it. I'm pretty sure the people producing Slatosh's personal information were on their side. I know I didn't. So that's great. But I know who had access to it. Shane Holmberg. Shane Holmberg knows a lot about Chris Slatosh. Shane Holmberg was working with Kamea-Khan before getting fired by Kamea-Khan. So, who might have leaked Slatosh's affidavit? Would it be the people or not Slatosh's affidavit, Slatosh's personal information, would it be the people trying to get in the good graces of someone to bring Vic back? Or would it be a salty little baguette who was fired and was openly disparaging everybody involved with supporting Vic? I wonder. Or maybe it was any of the other number of people who were talking about. Maybe it was Renfamous, right? Renfamous, who waited until Vic was announced, then bought a ticket, then tried to refund it, and then lied about it on social media. Maybe it was one of the known liars on the Kick Vic side who did it. But I know who would never threaten that. That's me. That's me. I would never threaten that. I know, well, I don't know, but I strongly believe that Ty would not do that either. That doesn't seem to be the way that Ty does business. But Lemoine wants Slatosh to testify to that. And further, he wants ultimately Slatosh to testify that he didn't sign that affidavit or something like that. That's what he's going for, right? Ultimately, he's trying to bring the notarization of that affidavit into a fraud because he's trying to, without making a motion on it, because he already basically did and it was ignored, trying to slide in this thing. Again, I would be shocked. Plus, there's already on the record statements about what happened there. But he doesn't want to openly call Ty a liar. Doesn't want to do that to the court. I mean, he wants to, but he knows the repercussions if he's wrong. There was no liquor in here. Okay. So, yeah, Lemoine wants Slatosh to commit perjury in his party's favor. Yes. And how's he doing it? How's he doing it? By threatening a deposition that'll cost Slatosh a bunch of money. By threatening to release Slatosh's information publicly, right? Okay. On to the motion for sanctions. And this is what I have been waiting to see. Fight back against these gross people. Plaintiff asks the court to award sanctions against defendants and their counsel pursuant to Rules 13 and 215.1d of Texas Rules of Civil Procedure and Chapter 10 of the Texas Civil Practice and Remedies Code on the grounds that defendants' motion to compel deposition documents of Chris Slatosh is frivolous, has not basis in law or fact, and because defendants have unnecessarily caused plaintiff to incur costs and attorney's fees in responding to the baseless motion. Notice who didn't do this. Volney didn't do this. Sam Johnson didn't do this. They didn't bother with this. Why? Why? Because this is ridiculous. And they know it. And they know it. Sanctions under Rule 13. Plaintiff seeks sanctions against defendants pursuant to Rule 13 of Texas Rules of Civil Procedure. Rule 13 provides the signatures of attorneys or parties constitute a certificate by them that they have read the pleading motion or other paper, that to the best of their knowledge, information, belief formed after reasonable inquiry, the instrument is not groundless and brought in bad faith, or groundless and brought for the purpose of harassment. If a pleading motion or other paper is signed in violation of this rule, the court, upon motion or upon its own initiative, after notice and hearing, shall impose an appropriate sanction available under Rule 215 upon the party who signed it, a represented party, or both. Rule 13 provides groundless for purposes of this rule means no basis in law or fact and not warranted by good faith argument for the extension, modification, or reversal of existing law. Notice they haven't done that second part. They may claim that there's basis in law or fact. Obviously, they'll have to argue that against this, but they have not argued that they're arguing for a change to the law or a modification or an extension of the law. They're merely arguing that that they have the right to do this. As detailed above, defendants' attempts to compel the deposition of Chris Slatosh are in clear violation of the plain language in Chapter 27 Texas Civil Practice and Remedies Code, which suspends all discovery absent specific allowance by the court for limited and specific discovery. Defendant's conduct has damaged plaintiff in connection with opposing the improper deposition. Sanctions under Rule 215. Plaintiff seeks sanction against defendants pursuant to Rule 215 of Texas Rules of Civil Procedure. 215 provides, quote, if the motion to compel discovery is denied, the court may, after opportunity for hearing, require the moving party or attorney advising such motion to pay to the party or deponent who opposed the motion the reasonable expenses incurred in opposing the motion, including attorney's fees, unless the court finds that the making of the motion was substantially justified or that other circumstances make an award of expenses unjust. Additionally, Rule 215 further provides, if the court finds a party is abusing the discovery process in seeking, making, or resisting discovery, or if the court finds that any interrogatory or request for inspection or production is unreasonably frivolous, oppressive, or harassing, or that a response or answer is unreasonably frivolous or made for purposes of delay, then the court in which the action is pending may, after notice and hearing, impose any appropriate sanction authorized by paragraphs 1, 2, 3, 4, 5, and 8. So there you go. Defendants, in seeking the deposition of Slatosh, have indisputably violated the discovery suspension provided for by the TCPA. Even if Slatosh's testimony could be relevant, as discussed above, it's not. The discovery would not be permitted without an order allowing said discovery. Thus, defendant's action should be appropriately sanctioned. Defendant's motion to compel should be denied and costs and attorney's fees awarded to plaintiff for having to oppose the baseless discovery request and motion to compel. Again, I'm not sure that the TCPA stay is still in effect, but if the TCPA stay is not still in effect, they're outside of any discovery period still and should have petitioned the court for a request for discovery. They're clearly not in post-judgment discovery because the judgment hasn't been imposed yet. And they're outside of Discovery Control Plan 2. So, yeah. Defendant's motion to compel should be denied and costs and attorney's fees awarded to plaintiff for having to oppose the baseless discovery request and motion to compel. Sanctions under Chapter 10. Plaintiff further seeks sanctions pursuant to Chapter 10 of Texas Civil Practice and Remedies Code, which provide signing of a pleading or motion as required by the Texas Rules of Civil Procedure constitutes a certificate by the signatory. Signatory's best knowledge, information, belief, formed after reasonable inquiry. The pleading or motion is not being presented for any improper purpose, including to harass or to cause unnecessary delay or needlessly increase the cost of litigation. And it is absolutely all three. Lemoine tipped his hand in his email to Slatosh that says, we could work it out that you don't have to do the deposition if you just do what I say, if you just tell me what I want to hear. How do you come to me? On the day of my lungs funeral? You ask me. You tell me these things that I cannot hear. What I have to hear is that Ty forced you to lie. And if you don't want to tell me that Ty Beard forced you to lie, we're going to have a big problem. Each claim, defense, or other legal contention in the pleading or motion is warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of a new law. Each allegation or other factual contention in the pleading or motion has evidentiary support or, for a specifically identified allegation or factual contention is likely to have evidentiary support after reasonable opportunity for further investigation or discovery. That one, they don't have a prima facie showing to suggest that Slatosh perjured himself. Period. They don't. They don't have a prima facie showing. They just have a baseless allegation. There's no evidentiary support. There's no affidavit in support of it. There's no testimony provided. They don't have any showing to suggest that he perjured himself in his affidavit. None. Lemoine's masturbatory writing style may have gotten the better of him. And each denial in the pleading or motion of factual contention is warranted on the evidence or for a specifically identified denial is reasonably based on a lack of information or belief. Texas Civil Practice and Remedy Code, section 10.001. A court that determines that a person has signed a pleading or motion in violation of 10.001 may impose a sanction on the person, a party represented by the person, or both. Nova Zero says, hey, Nick, is it possible for judges to issue or file for a court order to restrict movement against a lawyer? Is that a thing? Because if there was a case for Chup to file the one against this weirdo, this might be it. Wait, restrict movement? Do you mean like restrict the filing of motions? Or do you mean literally to restrict Lemoine from moving? Listen, the court says you cannot raise your hand to your mouth with food in it. That's too much motion. Stay there and die. Stay there and die. Defendants, if you mean restrict motions, it would take a lot. No, they'd just do it through sanctions, though. They would just keep sanctioning them with frivolous motions, if that's what you're talking about. Excuse me. Defendant's motion to compel deposition documents of Slatosh is brought in violation of TCPA discovery suspension. As discussed in detail above, the discovery was not permitted, and defendant's motion is not warranted by an existing law or non-frivolous argument for the extension, modification, or reversal of existing law or establishment of new law. The motion is, however, brought for the improper purpose of needlessly increasing costs, subjecting plaintiff and a third party to harassment. Accordingly, plaintiff asks the court to award sanctions under Chapter 10 of the Texas Civil Practice and Remedies Code against defendants and their counsel. Prayer, give us money. Give us money. This was brought by Ryan Sellers of Martinez Sue. And, there you go. Oh my. Oh my. Oh my. That is the motion here from Vic's side. I'm not trying to make you yawn. I'm so sorry. So sorry. Okay, let's do this Ridge wallet thing, and then we'll hit Funimation's motion. So there's Funimation's motion. We'll do the Ridge wallet thing real quick. It won't take too long. Okay, let me bring up the where is it? Where is it? Ridge. Ha! Ha ha! Okay, so it's ridge.com for the fans. This is their carbon steel wallet. I just got it today. I'm going to switch over to it. Mainly because this one has the money clip, right? My other one has the money strap, which works just fine. But I feel it gets a little cumbersome to like put stuff in the strap. I'm not the biggest fan of the strap itself. You can get any of their wallets with a clip or the strap, or you can order an extra one. You can actually have one on both sides if you really want. I don't know why anyone would do that, but these are carbon steel. They're super thin. They're super light. You know, I wager this clip actually has the most weight on the entire thing. But this is what they look like. This is how big they are. I really like them. They're sexy. Got this little pattern on them. Ooh, pattern. And also, this is the Ridge knife. It's got a clip as well, so it can clip onto your pocket or whatever, or your utility belt if you're Batman. It is square. It is also carbon steel. The handle is very light. It's got the flip out blade. Blade is black. I don't know if it's sharp. Should we test it? Maybe I shouldn't test it live on air. I have something I can cut. Oh. Aha! This is this HyperX Cloud. This is for my headphones. So, I don't know. This could go wrong. Oh, no, that's pretty good. It's pretty good. Well, that wasn't good. But, yeah, it cuts through paper and stuff. It's relatively sharp. Oh, this was double thick paper. Oh, there you go. I made a snowflake. That's a Minnesota joke. Sorry. But yeah, here's the knife. Pretty. It's nice. It's just got a manual lock on it. Oh, I did that off camera. Terrible. Terrible. Let's try that again. It's just got the manual lock on it. So you know, this number. So there you go. Ridge.com /for the fans. Get you like money off of anything that you want to buy. It's like 10% or whatever, I think. So, yeah. I don't know. I like their stuff. I like their attitude. I like their stuff. I like that they sponsor this show. Like, of all things to sponsor, I mean, these guys like also sponsor Fantano. So, which is cool that they sponsor Fantano, but it's much cooler that they sponsor me because, you know, I'm over here calling people baguettes and stuff, and they don't seem to mind. So, ridge.com /for the fans. Check them out. Buy their stuff if you like it. I love it. I really do. I use this wallet every day, although I'm not going to anymore because I'm going to use a new one. So there's that. All right, guys. Thanks for doing that. Thanks for enduring a sponsorship. But sponsorships help me make content. So, you know, there we go. All right. Let's get that off of there. Let's get back to it. Get back to it. Oh my goodness, we got to zoom in. No, that's too big. Center that bad boy. Okay. Wallet giveaway. Shill. Oh, absolutely. Absolutely. Full shill mode activated. Wonder shill powers activate. Nova Zero says, hey, Nick, is it possible for judges to issue or file for a court order to restrict... Wait, I read that one. My bad. My brain broke. Okay. Oh, should I... Oh, well, we're going to have to talk about the GoFundMe. I will bring up the GoFundMe. Let me get it. Let me get it primed here. I will bring up the GoFundMe during this show. It's going to be mentioned in this document. I think. So, I can't get sponsored by Ty's law firm, you crazy man. People are already flipping out. If Ty sponsored if Ty's firm sponsored the show, we'd be in real trouble. I need to do Ridge a solid. What I need to do is have them sponsor one of the drunk streams, and I can get really super hammered and be like, buy the wallet now! What are you doing here? Get off the show and buy a wallet! That'd be good. I've always wanted to get like arrested and yell, do you know who I am? Or whatever. Earju says, cheers for the interview last night. Have a great stream. Yo! Hey, you're welcome, Earjuice. Thanks for interviewing me and all that. If you guys have not seen it, Earjuice has done a video very recently on the lore of John Michael Kelly. John Michael Kelly, who's a fan and friend of the show. His interview last night was kind of asking me about the John Michael Kelly situation, My answer was, who? Who is this? I don't know who that is. I don't know anything about them. And might I add, because I have not yet watched Earjuice's video, I still don't know who John Michael Kelly is. Let me clarify that for some people. I know what people have told me about John Michael Kelly. Okay? I know that he cried during some Discord call. Cried because people were telling him he was being an idiot and suggested that he stop. I know that. But other than that, I don't know really anything about this guy. And every time I ask him, who are you? He doesn't answer. So I don't know what to say beyond that. I don't know. I legit don't know anything about this guy other than what other people have said. I try to get information from the man himself, and I guess it's a man. Maybe that's being generous. But I try to get information out of him, and it just doesn't, nothing ever happens from that. So, but if you want to learn about John Michael Kelly, you can check out Earjuice's latest video in which he covers the lore about JMK. So that's that. How do I enter your code for the wallet? It's for the fans, all one word, and probably all capitalized. That's how. It's when you go to the checkout, there should be a promo code or whatever. Or you can go to ridge.com/for the fans. That works too. So, okay. This is Funimation Productions' motion for reasonable attorney's fees, costs, and sanctions. This is what the judge asked the parties for. What Lemoine did was not what the judge asked for. What the judge asked for was this. So we will see what they're going to request. I'll give you my thoughts on it. Let me state this. Whatever my thoughts are, my overarching prediction thought is that Judge Chup will award the defendants whatever they ask for. Okay? So, I think personally that Funimation has asked for things outside the scope of the TCPA. All right? I'm going to tell you what those things are. I'm going to tell you why I think they're outside of the scope. It's all itemized, so we'll talk about it as we go. That said, I think Chup will go ahead and give them what they asked for. Because Chup has already ruled on everything, he knows it's going to appeal. I don't see why Chup would spend a lot of time hemming and hawing over the amounts. And I think that's why Funimation offered what I consider to be a reasonable request for sanctions, which we'll get to. But I think Judge Chup is just going to say, fine, just do it, because it's already going to get appealed. And if it needs to be changed, the appeals court will rule on it de novo. They can have that argument there. They can have that argument at the appeals court. I don't need to deal with it. That's probably where Chup's going to go with this. That said, if Chup were trying to reduce the amount of issues on appeal, which I don't think he's going to, if he were trying to discourage people from appealing, which he already knows they're appealing, so that's probably not going to happen. But if he were doing that, he would award a very low sanctions fee and really, really work on trimming back the attorney's fees to specifically what can be directly linked to the TCPA. That's what Chup would do were he attempting to avoid an appeal. But he knows an appeal is coming. There's no reason for him to avoid it. So whatever I say about the specific things that Funimation asked for, my overarching thought is that he will grant this order. So expect that. Prepare yourself for that. That makes the most sense in this situation, since it's going to be appealed. Since the order for attorney's fees and sanctions will be reviewed de novo by the appeals court, the judge. And this is why Lemoine's actions are so ridiculous, is that he could have just asked for basically anything and gotten it. He could have. He didn't need some basis from Slatosh for sanctions. He didn't need anything. He's trying to show off. He's wrapped up in his own micro celebrity on the 30 people who read his protected Twitter. And you can see that, by the way, if you look at his tweets, if you have the ability to find them, you can see how stupid it is and what he's trying to do. He's showing off for Renfamous. Maybe he hopes Renfamous will come and put him out of his misery with one hell of a blowjob in that giant, disgusting blowhole of hers. Maybe that's what he's trying to do. I don't know specifically, because I can't get in the mind of an insane, mentally handicapped person. I can't do it. I can't do it. And I mean handicapped by disease. But so whatever his purposes are, he could have just asked Chup for literally whatever. And Chup probably would have said, fine. Fine. Read the writing on the walls. Lemoine, Volney did it. Johnson did it. Lemoine's just wasting filings, wasting money, trying to drive up costs. It's unseemly. And I imagine that Volney and Johnson probably aren't that happy with it. Otherwise, they might have signed on to the motions in support. But they didn't. They did that during the TCPA. They didn't do it here. Okay. So this is 125 pages of documents here, but I believe the filing itself is about 25 of those. And then the exhibits are the rest. Under the TCPA, Section 27.009, Funimation is entitled to recover its attorney's fees and costs from plaintiff Vic Mignogna. See Sullivan versus Abraham. TCPA requires award of reasonable attorney's fees to the successful movement. The same is true of sanctions. See Kinney versus BCG, Attorney Search Incorporated. Yeah. It's not entitled to recover its attorney's fees. It's entitled to recover reasonable attorney's fees. Minor difference. As set forth below, Funimation requests that the court award Funimation attorney's fees in the amount of $168,941 and court costs and additional expenses in the amount of $7,504. Funimation further requests that the court award Funimation conditional appellate fees for any unsuccessful appeal or petition for review filed by plaintiff in the amount set out below. Finally, Funimation requests that the court sanction plaintiff Vic Mignogna at least $25,000 to deter him from filing similar lawsuits in the future. So here the evidence that they have: the affidavit of Volney, Volney's resume, Christian Orozco's resume. This guy, I believe, is a paralegal or legal aid or something. Their invoices, a summary chart of the invoices, invoices for expenses and costs, transcripts of excerpts from YouTube live stream, October 4th, 2019. That's me. He put me in the document like a weirdo. Let's see. Screenshot from YouTube live stream and excerpts from deposition of Vic Mignogna. So, yeah, good job. Good job filing me in a document, Volney. Section 27.009A of the Texas Civil Practice and Remedies Code provides that the court shall award the moving party, quote, court costs, reasonable attorney's fees, and other expenses incurred in defending against legal action as justice and equity may require. Just so you know, the courts have interpreted justice and equity may require to giving discretion to the trial court to award a different amount than the reasonable. Like, they may determine the fees to be reasonable, that are cited, but reasonable as justice and equity may require, probably not going to apply in this case. Okay, I want to point that I'm not making a declarative statement. I've already stated what I think will happen in this case, but just as an informational point, that as justice and equity may require does give the trial court a level of discretion in determining what fees to award. They can award less than what the other side determines to be reasonable, It's not reasonable attorney's fees for the action or for the TCPA. It's reasonable attorney's fees as justice and equity may require. Now, here's a novel argument you could raise in this scenario. It's not novel, I'm sure. It's probably put out there. But justice and equity do not put Funimation, which is owned by a multi-billion-dollar parent company, on the same footing as the plaintiff. And the plaintiff brought the matter in good faith, which they're going to argue against, but you argue that the plaintiff brought the matter in good faith. The court determined the TCPA to apply and to exclude the claims. However, they're going to admit later in this document that the plaintiff is trying to stop people from destroying his reputation, which is something that is protectable by the courts. So that alone undermines their argument that it's brought in bad faith. So what you could say is a multi-billion-dollar corporation is certainly situated to pay the attorney's fees, or at least a good chunk of the attorney's fees, that the plaintiff shouldn't be forced to bear them, because firing him and making a public statement on it is the cost of doing business, and it risks a legal action. And that risk of legal action is something that is figured into in their bottom line budget, and they can go ahead and they're better situated to pay those attorney's fees. So justice and equity do not require Manana to pay the attorney's fees of Funimation. That's an argument you can make. It might even be a compelling argument. In this case, again, I think the judge will award attorney's fees to Funimation and to all the defendants, because he already knows there's an appeal on the table. He's not going to be able to stop that appeal. It's going to happen. And he has no incentive to do anything other than the minimum amount of work required, which is just award the people that he's already awarded the victory to whatever they ask. That's it. So. Texas Supreme Court has... Man, this is annoying. There we go. Has construed this provision to mean that the TCPA requires an award of reasonable attorney's fees to a successful movement. A reasonable attorney's fee is one that is not excessive or extreme, but rather moderate or fair. Counsel for Funimation, John Volney, provides the necessary evidence to support Funimation's request for attorney's fees and costs in his attached affidavit. In doing so, Volney follows the framework for proving attorney's fees from the recent Texas Supreme Court case, Rormuz Venture versus UTSW DVA Healthcare. See Exhibit 1, Volney Affidavit. Volney also considers the Anderson factors, which are taken from the case of Arthur Anderson versus Perry Equipment Company. Volney reviews his firm's invoices Volney reviews his firm's invoices. Oh my gosh, can I talk? On a month-by-month basis to assess the reasonableness of the task performed and to make discretionary billing adjustments. So what they did was they went through each of the months, and he took out some things that he determined to be unreasonable. What he's trying to do there is save the court the hard job of having to go through and find out all the frivolous stuff and the wasteful stuff. But, you know, this is clearly slanted towards Volney, and there's a whole bunch in there that probably shouldn't be included. If we're objectively looking for reasonable attorney's fees related to the cost of the TCPA, we're not going to find it. We're not going to find that number 168,941 that they've asked for will not be a conclusion of a reasonable attorney's fees look. But like I said, Chubb's going to award it, I'm guessing. In sum, Funimation seeks an award of the following reasonable attorney's fees already incurred in defending against the legal action brought by plaintiff, and that will be incurred in the event of an unsuccessful appeal or petition for review. Funimation's base calculation of fees incurred is presumptively reasonable. Ooh. Funimation's attorney's fees are presumptively reasonable because they are derived from the hours that Funimation's counsel and paralegals spent multiplied by their hourly rates. To establish the base calculation, Funimation must prove particular services performed, who performed those services, approximately when the services were performed, the reasonable amount of time required to perform the service, and the reasonable hourly rate for each person performing such services. These are the Anderson factors, which I think they cover them later, so I'm not going to cover them now. These elements are contained in LPCH's redacted invoices, which are attached as Exhibit C to John Volney's affidavit. The invoices show 1. What services were performed in defending Mignana's lawsuit, which LPCH team member performed each task, the dates when the services were performed, the reasonable amount of time employed for each task, and the reasonable hourly rate for each LPCH team member. As further explained in his affidavit, John Volney reviews the invoices prepared by LPCH and made necessary adjustments to reflect billing judgment and discretion. In doing so, he adjusted or excluded certain time entries where the time spent appeared to be more than that required for the task, where the time spent may have been duplicative, or when the time spent may not have been strictly necessary for Funimation to prevail on its TCPA motion and to seek recovery of its reasonable attorney's fees, costs, and sanctions. Then why'd you include the mediation amount, Volney? Why did you include the mediation, in which the judge ordered you to bear your own costs? After applying billing judgment, the amount sought by Funimation for attorney's fees already incurred is approximately 85% of the total fees incurred by Funimation since the inception of the lawsuit through the end of October 2019. The Anderson factors warrant maintaining the base calculation. Court should look to the following Anderson factors to determine whether to enhance or maintain Funimation's base calculation, including the time and labor required, the novelty and difficulty of the questions involved, the skill required to perform the legal service properly, the fee customarily charged in the locality for similar legal services, the amount involved, results obtained, the experience, reputation, ability of the lawyer or lawyers performing the services, the uncertainty of collection before legal services have been rendered, and whether the fee is fixed or contingent on results obtained. After applying the relevant Anderson factors, the court should award the attorney's fees requested by Funimation. Each relevant factor is addressed below. Okay, first, the time, labor, and skill required to perform the legal services properly and the novelty and difficulty of questions involved. As reflected in the detailed invoices and billing records attached to John Volney's affidavit, the time entries are reasonable and appropriate for the type of work required to represent Funimation in this case. These invoices include detailed time entries for each professional, for each day of work in this case, and each entry separately describes the task being performed by that person on each day. The hours worked on this matter reflect time on the following activities. Initial conference with Funimation to discuss the case background, strategy, and other client intake work. Reviewing the documentation underlying plaintiff's claims against Funimation, including Funimation's complaint and internal investigation documents. Legal research regarding the TCPA. Plaintiff's claims and Funimation's defenses in preparation for the TCPA motion to dismiss. Interviewing Funimation's employees. Drafting the TCPA motion to dismiss and a reply and supporting documentation. Drafting and filing of other motions, including motions to strike plaintiff's evidence, responding to plaintiff's motion to strike Funimation's evidence, a reply to plaintiff's objections, and motions to strike plaintiff's untimely second amended petition and exhibits. Responding to plaintiff's motion to continue the August TCPA hearing. Work with co-defense counsel regarding strategy on the motion to dismiss in response to plaintiff's opposition. That one probably shouldn't exist. Preparing for and attending the hearing on defendant's TCPA motions. Co-defense counsel these are not aligned people, right? There's not a conspiracy. They're not employees and they're not agents. There's no reason for Funimation to work with co-defense counsel regarding strategy. Funimation has no interest in co-defense's outcome on the TCPA, and suggesting that they needed to work with them at the expense of the plaintiff is disingenuous. Absolutely unnecessary for Volney to have anything to do with Markey, Rial, or Toye's defense. Preparing for and attending the hearing on defendant's TCPA motions. Attending the hearing on September 17th, where the court ordered the parties to mediation. That is not part of bringing the TCPA at all. This should definitely not be included. Preparing and attending the court-ordered mediation on October 2nd, again, should not be included because this involves costs that were ordered to be incurred by the parties. And preparing this motion and its supporting attorney's fees affidavit, that shouldn't be involved in the TCPA either. As reflected in Funimation's TCPA motion to dismiss, Funimation's counsel had to research numerous legal issues, including the standards and applicability of the TCPA to this case. constitutional questions, including application of freedom of speech and right to association to petition the underlying facts. Why would you have to do this, Volney? Why would you even have to research this? All the Twitter lawyers could have told you. Various defenses to plaintiff's claim. Based on the experience of Funimation's lead counsel, John Volney, it is his opinion that the requested fees are reasonable. Customary fee. Here, Funimation seeks fees based on attorney hourly rate ranging from $220 to $500 per hour, set forth in the attached affidavit. These fees are well within the range of fees customarily charged in this area for this type of work. Nova Zero says SJWs don't offer anything job related, so please do not suggest they will reward any kind of favors that require kneeling. Lemoine is hoping that he will be put out of commission via face sitting. You're welcome. Gross. Let's see. Amount involved in the results obtained. In this case, plaintiffs sought to hold Funimation liable for various alleged actual, consequential, and punitive damages. Through their representation, Funimation's attorney achieved complete victory without protracted litigation. The experience, reputation, and ability of the attorneys. Volney is a partner at LPCH, has been licensed to practice law since 1997. More than 20 years of experience handling complex commercial and civil litigation matters in jurisdictions across the country, including in-state and federal courts across Texas. Volney has been assisted by a mid-level associate, Christian Orozco, who's been licensed to practice law in the state of Texas since 2018 and California since 2012. Prior to joining LPCH, the associate completed a federal clerkship in the Western District of Texas. Volney has also been assisted by a paralegal, Scott Smoot, who's been a paralegal since 2000. Smoot was critical in streamlining discovery by providing summaries of documents and preparing necessary items for deposition hearings. Whether the fee is fixed or contingent, the fee in this case is based on fixed hourly rates and is not contingent upon the outcome of the case. Funimation is also entitled to recoup $75.04 in costs and expenses incurred in this matter. In addition to reasonable attorney's fees, Funimation requests the court award Funimation costs and expenses incurred from inception of the lawsuit through the TCPA hearing. Westlaw charges, in-house copy charges, third-party copy charges, deposition transcripts, parking charges, hearings and depositions, mediators fees, nope, TCPA hearing transcripts, for a total of $75.04. These costs and expenses are properly supported by the attached affidavit. For all the reasons set forth above and in the attached affidavit, Funimation requests that this court find that the attorney's fees and costs sought by Funimation are reasonable and award them to Funimation in its final judgment of the case. Funimation is entitled to sanctions. They incorporate all the evidence and arguments made by co-defendants in this matter in support of their request for sanctions awards against plaintiff. In addition to the above, notice co-defendants haven't made an argument for sanctions at the time of filing. So, good job. In addition to the above, Funimation seeks a sanction award of no less than $25,000 against Mignogna to deter him from bringing similar lawsuits in the future. Section 27.009A2 requires that the trial court to award sanctions if it dismisses a claim pursuant to Section 27.003 and gives the trial court broad discretion to determine what amount is sufficient to deter the party from bringing similar actions in the future. Under the TCPA, a successful movement is entitled to sanctions to deter the party who brought the legal action from bringing similar actions described in this chapter. Courts considering the appropriate amount of sanctions under the statute have awarded between $100 and $1 million. Courts have broad discretion to determine what amount is sufficient to deter the party from bringing similar actions in the future under the TCPA. Upholding a sanctions award of $75,000 based in part on the broad discretion afforded the trial court by Section 27.009. That's citing Kinney. Although the court does not need to explain how it reached sanctions amount, court can consider the following to determine the sanction award: the defendant attorney's fees as a guidepost in the non-movements litigation conduct. See it at 11. Quote, it does not expressly require the trial court to explain how it reached its determination. See also Lowe versus Henry. Here there are multiple reasons why Mignogna should be sanctioned to deter him from bringing similar suits in the future. We'll get to those in just a second. Let's read this footnote. Laura Lee Prather and Justice Jane Bland article, Legal Law Journal article, The Developing Jurisprudence of the TCPA. Citing order awarding attorney's fees sanctions McGibney versus Retzlaff. Blah, 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 blah. Citing a whole bunch of stuff. Oh, it's just a giant citation. There's actually nothing to read in here. It's a bunch of different sanctions awards all over the place. So I'm not gonna read through that. You guys can see it on the screenshot if you want to read it. Read it. Save it and read it. First, sanctioning Mignogna at least $25,000 is justifiable and appropriate because there's a real risk that Mignogna will file more lawsuits against people who've commented publicly about him. During his deposition, Mignogna freely admitted that he may sue other people who he believes harmed his reputation. Yeah, harming a reputation is actually an actionable offense. So you've made the argument that he brought his lawsuit in good faith. The court is positioned to remedy a loss of reputation through defamatory action. So yeah. And you can say you might sue other people. You can actually do that. That's okay. Thus, his own testimony shows that he must be deterred from filing new lawsuits against his perceived enemies. Again, only if those lawsuits are frivolous. You'd have to show that he must be deterred from filing frivolous lawsuits. This is the problem with the TCPA. The TCPA dismisses by technicality that which is otherwise meritorious. And this is a real problem for the defendants. Because right now, they know that part of the reason that they prevailed is because Judge Chupp refused to include the affidavits of Vic Mignogna, Chuck Huber, and Chris Slatosh. They know that. So the problem is right now, based on a technical rule that may or may not have been applied correctly by Chupp, it wasn't. They have dismissed an otherwise meritorious lawsuit. However, if someone is defaming you and destroying your reputation through defamation, you have every right in the world to sue them. You have every right to pursue a lawsuit for someone who has admittedly damaged your reputation. You do. There's no questioning that. The TCPA, by its overly extensive power to the defendants, distorts the reality that you have a right to request redress from the court. You don't have a right to harass people through a lawsuit that's frivolous. But that's not what happened here. And I think even the amount of attorney's fees shows that that's not what happened here. And the fact that they went to deposition. And I think that should probably be argued by Vic's side. Look, if these people thought this was definitely frivolous, they could have filed from the start for the TCPA. They chose not to do that. It wasn't obviously frivolous. Look at how much cost they're claiming they had to put in to merely determine that it would be frivolous. The court happened to agree. But if it was obviously frivolous, they drove up the court costs intentionally. That must be the answer. Again, I think Chupp is going to give them what they ask for. But to suggest that someone stating, look, if someone commits a tort against me, I'm probably going to, or I might sue them. There's nothing weird about that. If someone runs over my child with a car, I might pursue litigation against them. Should I be dissuaded from doing that? From exercising my right to collect on damages? No. This is an inherent problem with the TCPA. It's not a bad argument by Volney, but it's an inherent problem with the TCPA. That being said, JCF Data says, wait till you get to the not yet billed fees, page 72 to 79. The amount of costs in determining the costs and sanctions is huge, like more than requested sanction amount. Yeah, the not yet billed fees is great. We'll check that out. Okay, the risk that Mignogna will file additional lawsuits is elevated here because unlike most litigants, Mignogna is not paying any of his own legal bills. Instead, this case is crowdfunded by a GoFundMe account. We got to bring up the GoFundMe. So here we go. Here, the butthurt has started over this GoFundMe right here. So the GoFundMe is at, let me make sure, $257,193. Thank you to Anonymous, Teresa Burns, and Mikkel Ostergaard, and Anonymous for your donations. $257,193. Thank you so much for that. What's interesting is Volney can't support that Vic has not had to pay any legal fees. He's just stating that. He's just stating that absent evidence. The last time that they talked was that they spoke about this was at Deposition months ago. I have no idea. The amount of attorney's fees that are billed to Vic Mignogna. I don't know what's been billed. I don't know what the bill is. I don't know if he's incurred additional expenses since. I know nothing about that. But what I do know is that Volney has no idea the dollar amount that Vic is paid. And he's stating it absent evidence. Instead, the case is crowdfunded by a GoFundMe account named Vic Kicks Back, started by an internet lawyer in Minnesota named Nick Rekieta, who regularly appears on YouTube to stir up Mignogna's adolescent supporters. Citation needed, Volney. Citation needed. Most, I would argue, the overwhelming majority of Vic supporters are adults. Not adolescents. In fact, I'm pretty sure you can't contribute to GoFundMe as an adolescent. And to raise money for Mignogna to sue his accusers, footnote 4. In fact, it was Rekieta who referred Mignogna to Ty Beer to serve Mignogna's counsel in this case. Yep, that's a fact. I did do that. Let's see. The Vic Kicks Back GoFundMe campaign managed by Rekieta has raised over $250,000 to fund lawsuits to kick back at Mignogna accusers. Yeah, like your company. Importantly, Mignogna knows about the GoFundMe, sort of. He doesn't really seem to know anything about it, though. That's supported by the deposition. And approves of it. Yes, I suppose he does. What's he supposed to do? Say no? I didn't really give him an option. I'm gonna pay your attorney this money. I'm gonna raise this money for you. People want to give you money. People want to support you. So I'm gonna give them a way to support you. That's what's in his deposition. He said I didn't ask him. I just set it up. I'm going to give people an avenue to support you because they're begging me to do it. You left that out, though, Volney. You left that out. That your client is so despicable that people begged and pleaded to give money to Vic to fight back against this. So, we'll see. Maybe I'll submit an affidavit. I don't know. Let's see. Where were we? Because of the GoFundMe, Mignogna has never felt the pain of paying legal bills. Yes, he has. Yes, he has. That $250,000 is his money. So this is patently untrue. That was money given to him by supporters, and it goes to the GoFundMe. Or it goes to Vic. I mean, it's for the benefit of Vic. It's his money. That's $250,000 of his money that he doesn't get to have. This is an insane argument. It's an insane argument to say that he's never felt the pain. If he felt that pain because of a robust sanctions award entered against him by the court, he might think twice before filing another frivolous lawsuit. Volney, you're a liar. This is his money. It's his to do whatever he wants. That's paying his legal bills, sure. But he could pay his legal bills in a different way. That's up to him. It's his. It's for the benefit of Vic. It's in trust in an account for the benefit of Vic. It's not my money. It's not Ty's money. Ty can bill against it, sure. But you know that that is in an IOLTA account for the benefit of the client. That's the client's money. Not Ty's, not mine. So don't lie. Why are you lying? Why are you always lying? I hope Martinez and Sue and Beard and Harris, Bullock and Hughes bring that up. Because that's Vic's money. That's $250,000 that he otherwise had. So, you know. Now they can try and argue that it would be less based on him not bringing a suit. Maybe it would, maybe it wouldn't. We don't know. We have no idea. But either way, that's his money. Say he hasn't felt the pain of paying legal bills? You take $250,000. Hey, Volney, you take $250,000 that someone's going to give to you and you turn it over to someone else instead. Sign that third-party endorsement on the check and give it to him. See if that's not painful. In addition to elevating the risk of future lawsuits, the GoFundMe has created an environment that encourages Mignogna to attack his accusers in court. He hasn't attacked his accusers in court. He's been really fucking gentle with you babies. God, I wish they would attack you like the pieces of garbage that you are. I wish they would. I wish he'd attack you out of court. I wish he'd point out what you've done to him. I wish he'd call out the sexual exploitation of your employees. I wish he'd call out the fact that you have a guy named Chris Sabat who apparently, allegedly, edited for the purposes of sexual humiliation the audio of a female voice actor to go ahead and humiliate her based on her sex. I wish he'd call that out. I wish he'd do that publicly and privately. I wish he'd point out all of the people and the sexually charged atmosphere that is so grossly offensive from Monica Rial, because no one wants to picture that thing naked, or Jamie Markey, the roving goblin. I wish they would bring all of that stuff out in court and in public. I wish they would do that. But they've been pretty gentle to you. They've been pretty gentle on what you market to children. Volney, what your clients market to children, which is an overwhelmingly sexually charged and derogatory towards women product, overwhelmingly treating women as sex objects, just massively. Anime titties are a thing. They're a huge thing. You have a harem anime. You have a whole genre of anime dedicated to women as sex objects in favor of one male. Like, think about what you are saying. They have been gentlemanly in this entire thing. I wish they would attack you in court. I wish they would attack you guys in public. It'd be funny to me. It'd be funny to me to point out your hypocrisy. All right. Let's see. The Texan 83 says, adolescent supporters, I'm 36, Jack. At SH. Just because your remaining VA's fans are mentally 12 doesn't mean everyone who likes anime is. Learn and understand the fan base of the company you work for. Brian Dewig says, that's some mighty rich adolescents. $250,000 rich. Bryce Byerly says, as a 50-year-old man, I really got to thank that old charmer Volney as referring to me as an adolescent. Just lovely. Rekieta and Beard routinely appear together on Rekieta's YouTube program. Program? John, oh my God. To discuss this lawsuit. To attack Mignogna's perceived enemies. I'm not aware of Ty or I attacking anybody. Making fun of you people, absolutely. Attack them? How? How have we attacked anybody? More importantly, how has Ty attacked anybody. Because Ty's not responsible for any of the content on my show, other than his own words. And to fundraise for Mignogna's Vic Kicks Back legal campaign against his accusers. Woo, woo, woo. Here we go. Every time they mention it, we'll do this. We're at $257,198. Thank you to Ronald Knoop. For your recent donation. I'm going to bring this up every time Volney mentions it. Every time. Let's see. Sinrius Akari says Sayun Koko Monogatari is reverse harem anime. Oh man. So they've reduced men to sex objects. Okay. And they have the transcript from Exhibit F, transcript of excerpts from Rekieta's YouTube stream for October 4th. So here's part of the disingenuous nature of this. Let's point this out. So Rekieta and Beard appear together to discuss the lawsuit, true, attack perceived enemies, false, and fundraise for Mignogna's Vic Kicks Back legal campaign against his accusers, false. False, you lying sack of trash. Volney, I know you've got a transcriber on this. Here you go, Volney. Ty has not ever been on for an endorsement of the GoFundMe. Ever. And on October 4th, I specifically waited to discuss the GoFundMe until Ty was off the show. You're a liar. You're lying to the court, and it's beneath you. You're a good attorney and a pretty reasonable guy, John. Why are you lying about this? Why are you lying? You're lying about this October 4th thing. You're hoping the court doesn't realize that the parts that you transcribed, or the transcript with me and Ty, is separate from the screenshot that you include, which occurs later, after Ty has left. I've made a conscious effort to not have Ty involved in the promotion of the GoFundMe. You're a liar, and it's disgusting. I hope they call you out on that. For example, on the day that the court entered its order dismissing Mignogna's claims, Ty Beard appeared on Rekieta's YouTube program to explain that while he was unhappy with the court's ruling, Mignogna's game plan has always been to use a lawsuit to shine a light on all of this stuff. Yes, that's part of lawsuits, is to point out that this is all lies, especially when your reputation is on the line, and to force evidence to be produced that you guys can all evaluate. Yes! Yes, that is part of the game plan. There's nothing improper about that. And you know it. Most remarkably, Beard went on to claim victory for Mignogna, even though the court dismissed his client's claims that same day. A victory. Not victory. A victory. A victory. What I'm saying is that we have already, quote, Ty, we've already won a victory. We've already won a victory, and all the people in tweet world that don't like that, tough stuffins. We have won. The only question is how big of a victory are we going to win? That implies that there's more victory to achieve, John. How big of a victory? How big is that? That's an implication that there's more to do. So, the people out there that hate us are, you guys are pissing up the wrong tree because we've already won. We've already won. And you can't deny it. But here's the thing. Vic is out there and people are standing in line for hours to see that man. Doesn't sound to me like y'all accomplished anything, just saying. This does not mean that they think they won at court, John. After Beard signed off, Rekieta went on to trumpet recent donations made to the GoFundMe. Woo, woo, woo. Yes. Yes. To the GoFundMe. Here it is again. $257,198 in the GoFundMe. Again, Vic Kicks Back is the GoFundMe. There's more to come. There are appeals. This thing has got 6+ months left in it. That's the reality. The appeals process takes a while. We have to get a ruling on the sanctions, which is going to come probably at least a month from now. At least a month from today for the ruling on the sanctions. Then you've got several months in appeals. Even if the appeals court dismisses it out of hand, we've got several months. So this GoFundMe, as I've stated, will stay around through the duration of the lawsuit. Volney, again, is going to be disingenuous here. Let's see. After the court's dismissal ruling. The dismissal is not the end of the suit. And you know that. You know that. Exhibit G. Beard and Rekieta's statements showed this lawsuit and any others that Mignogna may file with his GoFundMe money have nothing to do with the legal merits of the claims. False, you fucking liar. But are instead part of an ill-advised public relations campaign designed to arouse Mignogna's adolescent supporters. Ill-advised? Ill-advised. Okay. It's either an ill-advised lawsuit or an ill-advised public relations campaign. Pick one, John, because all of the people have said, well, they should have done public relations, right? They should have hired a PR firm. Well, which one is it? Is it a lawsuit or is it public relations? Or is the truth is that you want him fucking dead and you don't care what he does because nothing is good enough other than him being buried in the ground? Which one is it, John? Or are you just lying now? Are you just lying now, John? Because you know that if your reputation, they don't care. There is no win for Vic in this situation. He's just supposed to accept that social justice cancel culture has deemed him to die alone and hungry. Period. 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 How dare he fight back, right? How dare he file a lawsuit? How dare he try and conduct a public relations campaign? And by the way, a public relations campaign, for that you'd hire a PR firm. But how dare he fight back? How dare he say, no, I don't want to die because I didn't rape anybody. But he should have just taken it, right, John? He should have just accepted that your company fucking defamed him, right, John? Because you know they did. And you're a liar, and this is beneath you as an attorney, and you know it. But John, I've got a message for you. Not only did Vic not hire me to do a public relations campaign, Vic had nothing to do with any of it. All Vic did was say that the GoFundMe was legitimately being directed to his attorneys so that people weren't concerned about the fraud that you people have been lying about the entire time. That's it. Have you seen Vic out there saying anything to support himself? No. A public relations campaign would have Vic at the front of it. I wish there was a public relations campaign. I do. I think it would have been great to run in tandem with his lawsuit. I wish a highly sophisticated PR firm would have been involved who could have run this and just run roughshod over your bitch ass and your bad employee or your bad company that you represent, your bad co-defendants who are disgusting people. I wish he would have taken all of the gloves off of everybody and done that. But he didn't. What public relations campaign? You've got a bunch of YouTubers who supported a guy because he got unfairly accused of things he didn't do that you still haven't produced evidence for, that you specifically state you didn't mean to say they did, you liar. You know you're lying. That's the worst part, John. You know that the affidavits from your client state that they never meant to infer that Vic committed sexual assault or harassment of any kind. You've said it. But you're a liar. Because you could take the tweet down. You could have taken the tweet down in February. Could have taken the tweet down in March. You could have taken the tweets down in April, May, June, July, August, September, October. You could have taken them down at any point. The damage was already done. You've already accomplished your purpose. You could have taken the tweets down, but you didn't, did you? Because you did mean to convey that he committed some sort of sexual assault or harassment, because Barreto lied under oath. And so did Karen Mika, and you're lying in this pleading, and you know it. And you know it. That's the most disgusting thing. You're lying to the court right through your teeth. Given these unusual circumstances, Mignogna and his advisors intend to continue to raise money to file additional lawsuits against Mignogna's accusers. Whoa, wait a minute. How do you know that? That's baseless. That's absolutely baseless. Without regard to the merits of those lawsuits, citation needed. Citation needed. That's absolutely ridiculous. John Volney is claiming to have an inside look at the strategy of Vic Mignogna, legal strategy that I don't know about. I'm betting Vic and Ty don't know about that legal strategy. This is based on absolutely nothing, and he certainly hasn't provided evidence for his claim that Vic intends to file lawsuits against other people. I have said that this GoFundMe will remain open during the pendency of this lawsuit. I haven't said that it will be available for other lawsuits. I don't know that there will be other lawsuits. I would have to determine at that time, John. You're lying again. A sanctions award of at least $25,000 against Vic Mignogna will send a painful and personal message to him to avoid filing future frivolous lawsuits such as this one. Second, sanctioning Vic Mignogna at least $25,000 is also justifiable and appropriate because of his litigation tactics. See American Heritage. Award of sanctions was not abuse of discretion given the plaintiff's aggressive posture. In deciding whether a pleading or motion was brought in bad faith or for the purpose of harassment, the trial court must consider the acts or omissions of the party or counsel, not merely the legal merit of the pleading. Here, Mignogna used his response to Funimation's TCPA motion and a second amended petition, which wasn't considered by the court, to attempt to smear Funimation about irrelevant, untrue matters. What irrelevant, untrue matters? Rather than to provide clear and specific evidence in support of any of his claims against Funimation. See his second amendment petition, paragraphs 36 to 37, response at 1 to 2. That is not to mention the other miscues, fraudulently notarized affidavits, late and incomplete filings, and improper pleadings, leading up to the hearing on defendants' TCPA motions, which drove up the cost of the case and made the court's job more difficult. These facts justify an award of at least $25,000 sanctions against Mignogna. Yeah, the second amended petition was not considered by the court, for one thing, at all, actually. You have, which, if it was, you'd be in real trouble. Same with those fraudulently notarized affidavits, because the second amended petition would include the unsworn declarations, and if those were in, you would be in real trouble. You'd be in real trouble, and you know it. But either way, there's no smear against Funimation. Third, sanctioning Mignogna at least $25,000 is justifiable when compared to the total fees incurred by Funimation since the inception of the lawsuit through today. See Kinney, trial court's award of $75,000 as a sanction was proper based on the fact the defendant incurred $45,000 in attorney's fees. American Heritage Capital LP versus Gonzalez says, concluding that trial court did not abuse its discretion in basing its sanction award on the amount of the defendant's attorney's fees. Here, Funimation seeks substantially less in sanctions than the approximately $200,000 in total fees it has incurred since the inception of the lawsuit. Moreover, Funimation seeks less than the approximately $250,000 raised by the Vic Kicks Back GoFundMe to finance plaintiff's baseless lawsuit, using either Funimation's fees or GoFundMe. Oh, I forgot GoFundMe. Woo, woo, woo. Here we go. We have $257,615. Wow. Thank you guys for dumping money into the GoFundMe. Thank you to Brian Coates, Anonymous, Anthony Wood, Ryan Case, Joshua White. We've got some others here. David Wen, Dan Hughes, Paul Huang, Rob Martin, James Ketter, Anonymous, Sam Mark, Mark Whipple. Oh, thank you, Mark Whipple, for donating. And then Ronald Knoop, who we've already thanked. Thank you so much for continuing to contribute this to allow Vic to continue the fight. Every dollar helps. And again, since Volney's in the back, hey, Volney, I never said that the GoFundMe was the totality of fees that Vic would pay or anything like that. I merely have put it up as an assistance to his legal fund. That's it. You're disingenuous. You're lying to the court yet again. So, good job. Good job, John. Let's see. As a guidepost, sanctioning plaintiff at least $25,000 is easily justified. Conclusion, Funimation requests that the court award the following: reasonable attorney's fees of $168,941. Costs and expenses of $7,504. Conditional appellate fees of $50,000 for appeal, $25,000 for filing a petition for review. Additional $25,000 if the petition for review is granted but relief is denied. Sanctions of at least $25,000 at the court's discretion. So they're asking for $168,000 plus another $100,000, and then $25,000 for the sanctions plus $7,500 for the costs and expenses. Any other additional relief that Funimation may be entitled to receive? Okay, I'm not going to read the affidavit of John Volney. I don't want to go through all this. Well, we'll look at this. So, Volney is $500 per hour. Christian Orozco is $410 per hour, and Scott Smoot is $220 per hour. Just an important note about attorney's fees. Attorney's fees are not what the attorney makes per hour. So if you guys think John Volney is taking home $500 per hour, that's not true. Now, John Volney makes a good deal of money per hour, but this is a billable rate. A significant portion of this goes to the law firm. So just so you know, there you go. So here's all these things. Again, I'm not going to go through this. Oh, wait. We got to go through this part. Exhibit F is a true and correct copy of a partial transcript of a YouTube live stream entitled Reviewing the Vic Mignogna Decision. Re-upload. The re-upload is not a live stream. This is not a live stream at all. This is a video upload. How dare he? In the following link, I access this link and recognize that the speakers were Ty Beard and Nick Rekieta. You don't know me, bitch. Who discussed the court's October 4th ruling and the GoFundMe. We got another GoFundMe mention. Here we go. Here it is. We've got still $257,615 in the GoFundMe. I'm going to go back to my policy of bringing it up every time it's mentioned. Every time it's mentioned. Let's see. Established to bankroll plaintiff's lawsuit against defendants in this matter. Nope. It's actually established. You're incorrect, John. It's established for supporters of Vic Mignogna to support him in his efforts. It's not established to bankroll the lawsuit. It's to support him in his legal defense. In his legal defense. That means his defense of his reputations through legal means, whatever they are. Whatever they are. No matter how many times you have misrepresented it, no matter how many times you have decried it, it is there, and the people contributing to it are not adolescents. They are not adolescents. They are not incels. They are not broke broke homeless people like Duchette. They're not anything other than just people who support Vic Mignogna. That's it. They're supporting him. You can categorize it however you want, but it'd be wrong. Excerpts from the YouTube video were transcribed at my request by a court reporter from Dickman Davenport. Based on my comparison of the YouTube video with the written transcript, the transcript is an accurate written record. The referenced excerpts. You left out an of. At pages 1018 to 11.8 of the attached transcript, Rekieta discusses a Vic Kicks Back GoFundMe account. Here we go. I'm going to bring it up again. I know this is going to get annoying. I think we're going to be bringing it up a lot in the next couple days. Oh, and we're up to $257,820. Thank you so much to Jonathan Lynn, Brian Dewig, Brian Coates, Anonymous, and Anthony Wood, who I think Anthony Wood was on the last round. Ryan Case, Joshua White. Yeah, we read these. Thank you guys so much for contributing. There we go. Rekieta discusses the Vic Kicks Back GoFundMe account, which funds Mr. Mignogna's lawsuit. A true and correct copy of the reference screenshot from the YouTube video at timestamp 1 hour, 22 minutes, 51 seconds, which is attached here as Exhibit G, shows that there was $251,223 in plaintiff Vic Kicks Back GoFundMe account. I'm going to bring it up in just a second. As of that time, Vic Kicks Back GoFundMe account with additional commentary from Rekieta can be viewed at here. Yes, it can. Yes, it can. Right here. Thank you. That's GoFundMe.com/F for respects /Vic-Kicks-Back. Here it is. $257,820 worth of fuck you to Funimation, Monica, Marky, and Ron Toye. And may the fist be in you. May the fist be in all of you. Because you're all liars, you're all cowards, you all are disgusting, you've all lied to ruin a man's career and are now praying to fucking God that this TCPA technicality holds out. Because if you lose that appeal, you know, Drex is going to send the Mandingo squad to hollow y'all out. You know it's coming. If you lose on appeal, you are getting bent over. And oh my God, do I hope that just one claim from each party survives. And the funniest part is, you have to know that you're not getting $1 of this GoFundMe. Even if you win, you're not getting it. That's the funniest part of all this. Okay. This concludes my affidavit. I am John Volney, and I approve this message. John Volney is a sponsor of this live stream. Just so you know, John Volney fully endorses and sponsors this live stream. He definitely wants me to show the GoFundMe as many times as possible, because as a regular viewer from the Pinker Cox, listen, Pinker Cox? How have I never noticed that they have Pinker Cox? John Volney of the Pinker Cox has decided to endorse the GoFundMe, to inflate the amount of the GoFundMe through his repeated address of it. We know that is a regular practice on this. When reviewing documents in the Vic Mignogna case, every time the GoFundMe is mentioned, it is brought up as often as I remember. Sometimes I miss it. Okay, we've got these are their resumes. Oh boy. That's what's his face? Carrasco. I don't remember what's his first name? Christian Orozco. Not Carrasco, Christian Orozco. Woo! So there you go. No comment on Christian Orozco. I don't really care about the resumes. If you guys do, I don't care. Here's their these are their invoices. I don't want to go through all these. I really don't. Let's see. We've got look at this. Why are they meeting with counsel for Monica Rial and Ronald Toye? I think every meeting with Monica Rial and Ronald Toye has nothing to do with Funimation's reasonable attorney's fees. I would contest all of this. Funimation has a duty to defend itself, not to remember, these are not agents or employees of Funimation. Funimation has no interest in Monica Rial, Ron Toye, or Jamie Markey's defense. None. Zero. So they're going to charge $1,100 for meeting with them. Yep. Review status of service and contact blank, whoever that is. Call with blank. Call Ty Beard. Report blank. That's a $500 call. It'd be interesting if Ty has a record of how long this phone call was and if it was anywhere near an hour. Review pleadings filed by plaintiff. Conference call with defense counsel. They excluded this one. Review of documents. Attention to multiple emails. Multiple emails. Review Rule 11 agreement. They excluded this and the Rule 11 agreement. Attention to multiple new case filings and docket deadlines. Review materials received from client. What? That's $1,500. Continue review of materials received from client. Review web articles regarding Manana termination. That's $2,500. It's completely unaccounted for, whatever those materials are. Draft and email. Blank. Attention to draft answer for Funimation. Review correspondence between Funimation and Mr. Beard regarding notice under Texas Defamation Mitigation Act. $1,500. Identify defenses to be pleaded and defects in Mitigation Act notice. Which, by the way, they didn't actually object to the Defamation Mitigation Act, which you have to do by motion under the act. So I would contest that this $1,500 is pointless. They decided not to do that. This is what I would do, because I'm an asshole. I would say you didn't file a motion objecting to the Texas Defamation Mitigation Act letter. You didn't do it. So why are you charging $1,500 to review it? You didn't do anything about it. Further attention to drafting of answer for Funimation. Email communications, prepare materials, prepare for and attend conference call with co-defendants counsel regarding hearing. I would object to every one of these. Every one of these. Now they can do it. They can decide, like, let's be very clear. They have every right to strategize with their co-defendants. They do. But their defense is of their client and it's exclusive of the defendants. In fact, it may be in each defendant's best interest to avoid working with the other defendants. So to expect that the plaintiff will pay for your voluntary conference with the co-defendants, this isn't related to the TCPA, has nothing to do with it. In fact, it may be in direct opposition to your proper legal defense strategy. So to hold this over the plaintiffs, I think is incorrect. I would object to it. I'm guessing they will too. Attention to TCPA anti-slap motion research of recent cases considering such motions for defamation cases and cases involving public comment on allegations of sexual harassment. This is unquestionably within the proper request for attorney's fees. You should definitely do this. Like, this is right. So good job there. See, JCF Data says, Nick, look at the last invoice, the unbilled one at page 77 for calculating these fees. It's like 20K plus. Also, didn't see any filing from Lemoine today. Lemoine and Johnson likely just filed after 5 p.m. If they filed after 5 p.m., it'll go up tomorrow, and we'll probably be covering those documents tomorrow. Just so you know. Let's see. Draft notice and first rule 11 agreement. Attention to communications with opposing counsel. Download and cursory review of documents produced by Mr. Mignogna in response to subpoena Deuces Tecum. Report findings to Mr. Volney. Attention to multiple new case filings. At least attending hearing on motion to quash and for protective order. Provide email update. They didn't subtract 1.5 hours travel. So they're still billing for the attendance of the motion of the other party. This is not related to their hearing at all. But they're subtracting the travel out of that. Let's see what's next. This is a good look at the cost of litigation. It is astronomical. Research to locate various web articles relating to case on multiple anime and news websites. Download and save articles to shared drive. Okay. Review web articles and media publications regarding Mr. Mignogna. Attention. Look at how long it took them to research this stuff. 2.2 hours? Do you not know how to Google, John? Attention to multiple emails. Prepare for and attend teleconference blank. We have no idea who that is. Attention to draft answer from Funimation. Contact blank. I would oppose these on principle. Who the hell is this? Why do we think this has anything to do with this TCPA? Review blank. Create working. I'm guessing this might be review the report, right? The investigation report that they've refused to provide. Create working outline of events related to investigation and publications regarding Mr. Mignogna. Attention to multiple emails from counsel. Attention to multiple emails regarding depositions. Prepare for and attend teleconference with who? Review case law related to discovery after the filing of an anti-SLAPP motion. Case law... The law is pretty freaking clear, John. There is no discovery absent a motion. There's no case law that you need to review on this. Plain language of the statute. Further attention to draft answer for Funimation and follow-up. Review file to locate materials for review by Volney. Finalize and file Funimation answer. Review discovery received from defendants Toye and Rial. Prepare case materials for review by Mr. Volney. Attention to multiple new case filings. Attention to anti-SLAPP motion fact section. Review deposition notices for upcoming party depositions. Email co-defendants counsel regarding same. Provide update blank. It's got to be his clients who are redacted here. So he's excluded by 50%. Research case law and TCPA issues. Outline TCPA response and draft TCPA response. Okay. Sure. I guess you reduce these by 50%. This one should be reduced by 100%. Let's see. Attention to multiple new case filings. Prepare materials for review by Mr. Volney to prepare motion to dismiss. Attention to multiple emails from counsel. Attention to fact section of TCPA motion draft. 6 hours. 6 hours on the fact section of TCPA motion draft. Research case, they reduced these 50% because he's done this like 4 times now. Review deposition notices for Toye and Rial and docket deposition dates and locations. Research to locate various Twitter statements for review by Volney and prepare motion to dismiss. Prepare blank. Attention to fact and argument sections of TCPA motion draft. $2,000. Draft affidavits for Karen Mika and Tammy Denbo. So as expected, they were drafted by the attorney, not by Karen Mika and Tammy Denbo. Research case law and TCPA issues again. Prepare for and draft declarations in support of TCPA. Edit TCPA response. Confer with Volney regarding outside TCPA issues. Prepare blank. That's $328. That's fine. Research to locate. Wait, isn't his... No, his rate's $4.10 an hour. Never mind. Research and locate additional information regarding Funimation tweets for review by Mr. Volney to prepare motion to dismiss. What tweets, right? What tweets? There's no evidence that Funimation defamed Vic at all. They didn't present it, right? What tweets are you talking about, Volney? Is the legal profession fraud? Yes. Yes. Attention to draft affidavits for co-defendants, teleconference with counsel Rial and Toye regarding the same? Really? Why are we drafting? Why do we have draft affidavits for co-defendants coming to John Volney? I'd oppose that for sure. Continued attention to TCPA motion draft. Review plaintiff document production for possible deposition and or TCPA motion exhibits. Except they didn't actually do anything with document production. Edit declaration in support of TCPA. Prepare for and attend call with co-defendants counsel to discuss next steps. Again, I exclude that. Attention to multiple emails from Volney regarding documents produced by plaintiff. He's charging for reviewing Volney's internal emails. So Volney emails him, he reviews it, he charges. Review motion to compel filed by defendants Toye and Rial. See, these are reviewing the other party's documents that are filed is appropriate. Anything else? No. In my opinion, I would oppose these. Review documents produced by plaintiff to locate materials requested by Volney to prepare motion to dismiss. Begin preparing materials to be used as exhibits to motion to dismiss. Conference call blank. Don't know who's on that call. So there you go. Useful. Prepare materials for review by Volney to prepare for upcoming depositions. We're not even at the depositions yet, y'all. Attention to correspondence from counsel regarding location of depositions. Attention to preparation for depositions, including discussions with co-counsel Lemoine regarding the same. At least they excluded that. At least they excluded that. Attention to revisions to Mika affidavit, David Barreto affidavit. Attention to draft of Texas anti-SLAPP motion. Attend telephone conference, and telephone conference again blanks. Review documents produced by defendants Toye and Rial to locate any useful materials for review by Mr. Volney to prepare upcoming depositions. Attention to multiple emails from counsel. Travel to Fort Worth. Oh, they took that one out. Attention to trial notes, blank. Attend the deposition of Mr. Mignana. This isn't actually related to the TCPA. And I think that they're going to oppose, again, CHUP is going to award what they asked. Before my words are misconstrued, CHUP will probably award what they ask. But they will attend deposition of Mr. Mignana and depose Mr. Mignana. They should oppose this. There is no reason, as stated by Lemoine on Twitter, there is no reason for anyone to be deposed in this case. A TCPA is intended to eliminate a meritless action on its face, not following discovery, not following any of those other things. So if you choose to conduct discovery and it's clear from everything that Lemoine is working in concert with Volney, Volney and Lemoine are working together to increase costs unnecessarily. All they had to do, Volney could have filed his TCPA at any time. Volney refused to produce documents that were subpoenaed. They refused to participate in discovery except for the deposition of Vic Mignogna. That's it. That's the only thing they did. And they did it with the full involvement of J. Sean Lemoine, with co-defendants who are not co-counsel, who are not co-equal partners in defense, who are not intrinsically entwined parties. They are actually separate parties. Volney could have filed his TCPA, but he didn't because he was working with J. Sean Lemoine to prolong and increase the cost of the litigation. This is what I would argue. Absolutely argue that they improperly increased the cost of litigation by engaging in discovery that was unnecessary, because the purpose of the TCPA is to expeditiously dispose of frivolous lawsuits, not to engage in discovery, to go ahead and dispose of lawsuits that have no merit because there is no prima facie evidence. Discovery undermines that. And I know the court didn't rule that way, but I would oppose it on those grounds. Attention to multiple emails from counsel regarding Mignogna's deposition. Travel from Fort Worth for the deposition of Ron Toye. Why are they attending the deposition of Mr. Toye? They don't need to. I would oppose this. They didn't ask questions of Toye at all. Funimation didn't participate in this deposition. They could have just acquired the transcript. They didn't need to be there. Their party was not there. This is a completely elective thing. I would oppose this entirely. Same thing with Monica Rial's. $3,500 for $3,250 for Toye, $1,500 for Rial. Research case law on commercial speech exemption. Outline edits to TCPA motion to incorporate new portions. Attention to affidavits of Karen Mika, Scott Barretto, and Tammy Dembo in support of TCPA motion. Attend deposition of Rial. Research case law on right of association commercial speech exemption. Oh my God. Liquor's hitting me now. Liquor's hitting me. Yes, I burped. Sorry. That's the consequence of a live stream, y'all. Revised materials. Okay. I gotta stop. Or I'm gonna find a Minecraft server for myself. Let's go. This is just June. In June, they incurred $62,248 in legal fees because of those depositions. They incurred $49,557. Sorry. And then they had the previous balance of $12,691. I've been burping nonstop for the past 10 minutes. Ladies and gentlemen, alcohol use can lead to short-term memory loss. Oh my goodness. Let's go through. Let's go to the last page. I don't want to read through this. Look, I would oppose a lot of this. Oh, God. And again, opposing all of this doesn't mean the court isn't going to award it. I think they largely will. Because Volney has no reason to do more work on this. Not Volney. Chup has no reason to do more work on this. He has every reason to just award it. This is $27,846 this month. Litigation costs a fortune, guys. It costs a fortune. Let's see. Look at all this stuff. They've excluded a bunch of travel and drafting of emails. Sure. See, what Volney's doing here is he's excluding these things in hopes that the judge won't impose a reduction, that they'll accept Volney's reduction. If you remember in the Trump case versus Stormy Daniels, the judge actually imposed a reduction on their request for legal attorney's fee or for attorney's fees. They don't need to accept at face values what they provide. But Volney is attempting to pre-do that. Now you reduce it by 15%, hoping that the court won't reduce it by 20%, right? So he's excluding a lot of stuff here. Let's see what we've got in the last month. All of the stuff about mediation, I would oppose all of it. Like this, the court ordered all the parties to bear their own costs of mediation. I would oppose all of it. They don't get that. Court ordered opposite. And I would specifically call that out. Whether or not Judge Chupp agrees with that or not, he ordered it. He should agree with it, but whether or not he will, I don't know. So here we've got prepare for mediation. Amount 328. They switched to a new billing system, clearly. Oppose. Prepare materials for review by counsel to prepare for mediation. I'd get rid of that. They billed $600 in travel. They excluded that. Prepare mediation. Get rid of that. Attend mediation. Get rid of that. They were ordered to attend this mediation on their own costs. Get rid of it. I don't know why. Oh, Roscoe spent 2 more hours than Volney at mediation. So there you go. Communication with client regarding the court order. This is after the TCPA. This is not regarding the TCPA. They don't need to charge this to Vic. They should. I would oppose all of this stuff. Anything after the TCPA, I would oppose. Frankly, after the ruling. Joint defense communications with co-defendants related to attorney's fees, issues, and next steps. Definitely exclude. Other case ASSI. I'd exclude that. Teleconference with Mr. Lemoine. Listen, this has to be reduced by at least half because that guy's, 40%, right? It's got to be reduced by 60% to 40% because his lung capacity makes it take longer for him to communicate his side of the issue. So any call with Lemoine has to be reduced by 60% time. Let's see. Review case law and sanctions and attorney's fees. Nope. Get out of there. You don't need to do that. Because you can just put it out there. You can just request it. The court will go ahead and do it. Attention to research and writing of attorney's fees. So 1,000. Research case law and sanctions, $900. Research case law on attorney's fees, another $1,000. Conference with co-counsel for defendants. All this stuff. I would oppose everything post ruling. For sure. Further attention to attorney's fees affidavit. Look, you want to write a strong attorney's fees affidavit? That's up to you. But that's not a cost borne by the plaintiff. Anyway, so this is crazy. This just in October. October they incurred $35,286. This reminder, this is after the ruling. Now the costs and fees are awarded related to the TCPA. This is after the TCPA ruling. They incur $35,000 in fees. You've won. Now you get to just run up the fees as much as you want and charge it to the other party? No. I would oppose all of this. I'd oppose every single dollar. Okay. Let's see. What do we got? More invoices. These are from the transcript people. Let's see if we can find. Let's see how much it costs. How much it costs to transcribe my stream. Certified copy of Ronald Toye's deposition. Now, of course, Ty can check all of this for the costs. He can check all of this for the costs. And I would argue Again, if I were Ty, I would argue that that you don't owe the defendants anything. They were clearly conferring as co-defendants, that you don't owe them. Like if they have to pay, if each party has to pay for the deposition of Toye, or if they claim that they need to be paid for it, no. Why would you? You're co-defendants. You're arguing that you're co-defendants. I would argue against any of these costs being duplicated amongst the parties. Absolutely not. Why would I pay for all three of them when they're clearly working together? Big Red Bear says, is it not ridiculous that this is obviously frivolous, but the judge is likely to award this to them? Welcome to the law in America, buddy. Ridiculous is how we do things. What a joke, how absolutely criminal. This entire thing has shown me that I never trust the legal system due to biases. You shouldn't. You can't trust it. As I said this so long ago. I mean, people keep claiming that I somehow assured victory. I did not. I said that this case should proceed on the merits past TCPA. It should. And it absolutely should. Let me maintain that position. It absolutely should. Why do you think they want the affidavits and the second amended petition excluded? They know that those move past TCPA. They know they've won on a technical issue interpreted by one judge, and they may uphold it on appeal. They absolutely may. But no matter what, they know that they've won on a technical ruling by a particular retarded judge. Did I say that? By a particular mentally handicapped judge. They know that. They know that. That's why they have to exclude evidence. Think about the logic of this. The TCPA is designed, and by retarded, I'm using the French version, en retard. En retard means to be behind the times, or to be late, or to be tardy, to be behind the prevailing idea. And I think that absolutely applies to French. So when I say retarded, I mean it in the French. Retardé. Retardé. So there you go. The defense in this case must oppose the inclusion of evidence. Think about this. They know that they must oppose the inclusion of evidence because that evidence points to a meritorious lawsuit. That's the funniest thing here. And that is one of the biggest appealable issues, is that regardless of the time constraints on the technical reading of Rule 63 as interpreted by Judge Chupp, evidence exists which, if taken as true, points to passing the TCPA at the trial court level, period. And only upon exclusion of said evidence do they not pass TCPA. Which means that the court prejudices the plaintiff and dismisses an otherwise meritorious lawsuit on a technical ruling on the timing of filing of evidence. That's what's going on here. That is one of the largest appeal points and probably will be prominent in the appeal filing and in the oral argument, is that judges, because there are three, they are desperate to exclude evidence that points to a meritorious lawsuit because they know if it's included, they go past TCPA, and this lawsuit has merit. To exclude it is prejudicial to the plaintiff to the point where an otherwise meritorious lawsuit is deemed frivolous because we chose to ignore evidence. Not because the evidence doesn't exist, but because the court chose to ignore it. Think about what that means. And what the appeals court has to say, the appeals court has to say, look, due to a hyper-technical reading and interpretation of Rule 63, we are going to exclude evidence which we know will lead to the conclusion that this lawsuit has merit, and instead call it meritless. That's what the appeals court will have to do. The defendants know this. Well, at least their counsel knows this. That's amazing, by the way. That's amazing. Remember, to maintain the narrative that Vic's a sexual assaulter, the defendants are relying on a technicality to show that he didn't bring the evidence that he did bring. That's how they're trying to win this case. And that's what an appeals court will have to find. Appeals court will have to find that, yes, we see this evidence. We have determined that it was filed late, and therefore that merits the exclusion of a case that is otherwise meritorious. That's insane. That's insane. Big Red Bear. Oh, wait, no. JCF Data says that is not a new billing system. That is unbilled. Funny's first payment was 4th of October. I know it's unbilled, but they're developing the invoices probably through a new billing system, which is why they look completely different. See if we can find the cost of hearing held on September 6th. Oh, did they not include my thing? Conduct mediation. Oh, so this is from the mediator. Again, this shouldn't be included at all. This is cheap for 6 hours. Good job. Continue mediation efforts, 3 hours at $250 per hour. I had a mediation last 4 hours that cost that much. By the way, because the mediator had to prep for the mediation. That was great. It was great. So here's my excerpt of my transcript from my show. You can go back and watch the October 4th re-upload. Called it a live stream, but it's a re-upload. It's a re-upload of a live stream. How dare you, John, misrepresent the evidence like that? They've got excerpts that they wanted transcribed. So they watched it for free. Oh, that's embarrassing. So these are Ty's answers about a victory, and they're incorrect. Again. So this is all me, right? Talk to y'all later. Bye-bye. Ty's gone. All right, man. Have a good night. Bye. Okay, 1 second here. There we go. So this is me bringing everything else up. The rest is me. Audra Patty, certified shorthand reporter from Dickman Davenport. And then here's a screenshot. Who's in the screenshot? We've got Darth Luke, Checkpoint. Someone's message was deleted by Corono. Mary Ford, Sharon Young, Chad Simmons, Corrupted Singularity. Got something Thumburger. I don't know what any of these names are. So there you go. That's me. That's me alone promoting the GoFundMe. Suggesting that Ty has promoted the GoFundMe is disingenuous. But there you go. And here's the deposition of Vic Mignogna. This is the end of the filing. I'm gonna be done reading papers for today. Let's do one more look at the GoFundMe here. Here's the GoFundMe. Again, this will remain open as long as the action is pending, which means through the appeals process and any process after that. I don't know. I have no idea if there are other lawsuits to file. I know they're going to run into a problem with the statute of limitations on any other statements that were made back in January and February when this all was taking place. So I don't know if they're going to file anything else. To say that this GoFundMe is for the purpose of filing new lawsuits is actually disingenuous. John Volney is reading this in the opposite. Is reading this opposite to the intent of the lawsuit, and I may have to file an affidavit to cover it. Let's see. The fund is set up for Vic's legal defense fees. There are many possible defendants in different jurisdictions, from boring bloggers to multi-million, even multi-billion-dollar corporations. It takes an agile and experienced, not cheap legal team to coordinate this kind of strategy. I am not representing Vic in a legal capacity, but I am aware of the team who will coordinate this fund to pay for Vic's legal fees. Litigation costs are highly dependent on the actions of your opponents, so I'm hoping to raise enough to account for that. Spoiler alert, I was hoping to God to raise 50 grand. You guys have quintuple plussed the hope. I hoped to raise $50,000. I never thought in my life that $250,000 would be raised. Never. That's on you guys. You guys have done amazing contribution. An amazing contribution to that. And I can't thank you enough. I really can't. I know if Vic were on here, he would thank you all personally. Because he's that kind of guy. He shows appreciation to people who help him. I know he would thank you all. I can't thank you enough. I thought maybe we'd get 50 grand. I hoped. I set it at 100 grand as a lofty goal. And man, I hope we get 50. Because that would be cool. If we got $50,000, would have been a monumental achievement to me. A monumental achievement. I had no idea you guys would multiply that by 5 and then continue to support it. So thank you from the bottom of my heart. Thank you. Okay. We will announce disposition of any extra funds candidly and provide updates on the usage of funds to the extent such information can be made public. So far, none of it has been made public other than a lot of money has been spent. Since the defense is so highly seeking after a record of the GoFundMe, I haven't requested a disposition of the funding. I don't know how much it's cost. I have no idea. Zero idea of how much it's cost. You can imagine it's a lot. You saw how much Funimation charged, right? 170 grand. They actually they've billed 200 grand. It's entirely possible that the entire GoFundMe amount is accounted for. I have no idea. And most importantly, as the person who runs the GoFundMe, neither does Volney. Neither does Slatosh. Neither does Lemoine. Neither does Johnson. None of them know how much has been spent. That's between Ty, his firm, and Vic. Period. And for anyone to suggest otherwise, they're lying. But we can infer a large amount of money has gone into this litigation. We can infer that. Absolutely. I just don't know what it is. It's time to fight back. Brigades of pseudo-anonymous keyboard warriors cannot be allowed to defame and destroy decades of goodwill on rumor and unverifiable allegation. Companies cannot rely on non-credible accusations and devastate a career for virtue points. There is nothing in here saying additional lawsuits will be filed. There's nothing in here saying lawsuits will be filed. I want to point that out. I said there are many possible defendants in different jurisdictions. We have no idea how much is going to be filed. I don't know. So Volney is lying, saying that he's definitely going to sue other people based on the GoFundMe. So there you go. There you go. That's the end of that. Let's suggest a couple things here. I am going to go through super chats and justice chats now. Thank you all for hanging out with me tonight. I will be on Twitch. I will be on Twitch following this live stream. If you missed it earlier, I have achieved partner status on Twitch, which is weird because I've heard that's very, very hard to do. I'm not a great Twitch streamer by any means. I do intend to expand the content of the Rekieta Media Empire to Twitch, including daytime live streams on Twitch on subjects that are not related to law specifically. That'll be Rekieta Media primarily. This will be Rekieta Law. That'll be book reviews. That'll be movie reviews, anime reviews, whatever may take place over there, along with video game playing. That will be a separate show. I'm looking to increase the presence on Twitch, and that will be announced as I figure out when I can stream with a schedule on Twitch. That's the goal, is to set up another daytime schedule in which, if you guys have trouble watching live streams and stuff like that, there will be daytime content as well on Twitch. I just have to figure out what that daytime content will look like, where I can fit that into a reasonable, reliable schedule. That will happen. Also, in the alternative, my Twitch thoughterly serves another purpose, and that is, if you are subscribed to this channel, if anything happens to this channel that would prevent a live stream, the normal live stream, which would mean a community guideline strike, a copyright strike, whatever that is, if that happens, the live streams will continue on Twitch at the same time. I cannot broadcast to both platforms. Twitch partner agreement does not allow me to do that. Okay? But in the event that this channel is compromised in some way, the Twitch channel will be the backup destination. So if you want to be a part of that, please go follow on Twitch. It takes no effort or time, no effort or money. It takes just a second to go click on it, right? Go follow on Twitch if you have it. And that will be the backup place. You can find, if something happens to this show, all of the announcements, all of the live streams, all of the content will be produced on Twitch if that happens. R.I.P. Medicare. R.I.P. Medicare. So if I get Medicare for whatever reason, I will migrate to Twitch. You can find everything there. If you want to follow it now, that's great. If you want to follow it later, that's also great. But it is there. And the link is in the description. Twitch.tv/F/Rekieta Law. So there you go. That being said, let's go through these justice chats and super chats, and we will, as stated, go over to Twitch following that. All right. We've got Cowboy FMJ91 says, with the case going into appeals, would Vic have to pay these attorney's fees now or wait till appeals are finished? He'll wait until appeals are finished. Attorney's fees and sanctions are not part of the appeal bond. The appeal bond is something you put up while you go to appeals. And the appeal bond strictly includes the costs of litigation. So court fees and other reasonable fees. So at most, if the court were to accept Funimation $7,500, it'd be $7,500 plus the filing fees for Funimation. Likely, they would not accept the full amount of those fees as part of the costs. Those would be included in attorney's fees or something else, other awards. But at most, $7,500 for Funimation is what they've claimed as their costs. That's what they claimed. So that's the most the court will award, and that's the most that an appeal bond would require. Which, by the way, if you get an appeal bond, it's likely at 10% or less of the actual value. So the out-of-pocket expense for a $7,500 appeal bond is $750. So that's that. But no, attorney's fees will be a judgment, and on appeal, that judgment would not be in. I mean, they could try and enforce it, but it would be They'd have to try and enforce it, and it would probably be stayed. The only thing they could definitely get would be the appeal bond, which would probably, oh my goodness, which would probably be placed in possession of the court pending the outcome of the appeal. So there you go. Because if they lose the appeal, they don't get the money from the appeal bond. So you place it in the registrar's hands. The registrar of the court would hold on to that money, and then pending the outcome of the appeal. If Vic lost, they would turn it over to the defendants. If Vic wins, it would go back to Vic. That's how that would work. So I hope you said. Or I hope you said. Holy God, the liquor. It's getting to me. Hope that answers what you asked. Mercenary says, what is the worst case if Chup wants to be cruel? How much can he force Vic to pay? He can't force Vic to pay anything. He can issue a huge judgment that will be reviewed on appeal, period. All of this, by the way, will be reviewed on appeal. All of it. So one of the things that Vic's team is going to be doing in their responses is looking to preserve issues on appeal. The appeal is reviewed de novo, which means as if no judgment has occurred from scratch in its totality. That includes the award for sanctions and attorney's fees, and they will preserve the arguments on appeal on the sanctions and attorney's fees in their drafting, in their response to these requests. They will preserve issues on appeal and suggest that it needs to be lower. It needs to be lower than that. And then they will bring those issues with them into appeal on the sanctions and attorney's fees and suggest that the sanctions and attorney's fees are unreasonable and outside of the interests of justice. They'll do that. So all of this is still appealable. Whatever. That's why I think Chup will go ahead and just give them what they ask, is that all of this is going to be reviewed on appeal anyway. There's no reason for Chup to make an order for less than what they ask. It's very, very important. That's not actually a criticism of Chup. It really isn't. The whole thing is already going to be reviewed. They've appealed, including the pending sanctions and attorney's fees order. They've already appealed it. So Chup knows it's going to happen. He has no reason not to just give them what they ask and move on. Ty and company will have to file responses because they'll have to preserve the issues on appeal and suggest that, no, we argued against this and this and this and this on these reasons. They're going to definitely have to do that. But Chup has no reason to listen to Ty. That's an argument for the appeals court made before Chup. It's weird, but that's how it goes. Question says, shouldn't they argue for the GoFundMe amount that was available at the time of the lawsuit filing? They could try and argue for that. But I think it was already over the $25,000 by significant amounts. So I'm not gonna suggest that they do that. Survivor of Volney says, I will be quiet no longer. I was sexually assaulted by Sam Volney. Sam Volney? I can't remember the year it happened. It was sometime between 1896 and 2019, or the location. I'm 50% sure it occurred in the Northern Hemisphere, but it definitely happened. Hashtag slam Sam. TLJ Screwjob says, so much for round 2 then, huh? I don't know. Round 2 may happen, may not. I don't know what they have. I don't know what their intentions are. Statute of limitations run out in the middle of January, right? No, it depends on when they actually discovered the statements. And even if it does happen, then they could just go to Chup again or someone else and be in the exact same spot as he is now with them screwing with the truth. Well, a second lawsuit may not go before Chup. It may be a different judge. And we've seen that Tarrant County judges do not handle TCPAs in the same way Chup did. Not all of them. Pro Your All Might says, yeah, that's right, Nick. Rage and let these morons have it. Survivor of Volney says, oops, I mean John Volney sexually assaulted me, not Sam Volney. Sorry, my brain is traumatized from all the rape. My Shiro, Monica Rial, must be suffering from the same condition. Her story makes no sense either. That's how you know it's true. Hashtag jab John. John Volney, are you a rapist? Nicholas says, can we end the night on a lighter note? Has anyone ever called you Nickel Pickle or Nicky Nine Doors? I've been called Pickled Nick, but not Nicky Nine Doors. Fluffy Side Up says, in my opinion, reasonable fees related to TCPA should only include filing the TCPA and everything up until the judgment. Nothing before the filing and nothing after the judgment should be included. I may be wrong, but that's just how I see it. Well, you're not wrong. Someone may disagree with you and there may be a different legal conclusion, but that's how law works. You're not actually wrong in having that opinion. Interestingly, they didn't even have to file an answer. So the research and filing of an answer is not necessary. The research and filing of the TCPA could have been sufficient, but they chose not to do it that way. And they could have. They could have. They actually might have had a better case for TCPA had they filed immediately. But they didn't. And I'm sure that's what the plaintiff is going to be arguing. 2012 Jameson says, look up SNS emergency training versus Elliott, Texas case. Okay. 2012 Jameson says, I passed the Texas bar exam first try. Hey! Congrats, 2012 Jameson. I'm very happy for you. I'll look up that SNS emergency training. Absolutely. Angel Ren 89 says, so what's going on with Chuck Huber? Beats the shit out of me. Beats the ever-loving hell out of me. I have no idea what Chuck is on. I have no idea why he's aligning himself with people who would happily destroy him. I think if I can read the bones and the blood and the spit like in Robin Hood or whatever, that Chuck Huber is afraid. Why? I don't know. But that Chuck Huber is afraid that he's next on the chopping block. But it's not a conspiracy. There's no list of people called the Broken Staircase. There's no reason why these disgusting vindictive harpies would go after anybody who opposed them. There's no reason that Chuck Huber said in his affidavit that he was scared of retaliation by the defendants and by other people at Funimation. They're all just good people, right, Chuck? Right, Huber? They're just good people, right? Just put it in there, Chuck. Suck that Sabbath ball sack. You're embarrassing, buddy. Absolutely ridiculous of you. To think that they will spare you after what you said? If you just SJW hard enough? Good luck, man. Good luck. Funny, I would definitely do it. Maybe we should do that. Yep, you got him pegged. Emphasis on the peg. Say Brav says, Twitch chip, Day Glow tube tops. They're great. What are Day Glow tube tops? Comicsgate Live says it's okay to be Jewish. All right. It's okay to be Jewish. I'm with you. I think it is okay. I think it is okay. Awig even said he wasn't threatened. Oh, whew. Oh, man. That's a relief. I'm so glad he wasn't. I'm so glad he wasn't threatened. It's really good about that. Bad Vibe says Lemoine equals lame Heine. Lame Ash Lullier. Keck7 Go says, reminder that Rekieta doesn't know how to make roux. Keck, I will put you in the roux. Mo Diggity says, hey, Nick, I want my Vic shill dollars in a money bag. Okay, a $sign bag. I'll do it for you. Yeah, go ahead and reach out to Chuck to talk, Sarah. Best wishes to you. Talbot Link says, Roo, fight with flour. D-Man DOGO56 says, hey, Nick, where can I find more case docs beside Vic's original petition? Somebody I know is interested and would like to research it for themselves. Well, Shane Holmberg has a Google Drive link with all of the case documents. Otherwise, you can find all of them on the Kiwi Farms. Talbot Link says, Phil scheduled yet? No, he's not. He will be. I have made contact, but he is not scheduled. And that's on me. He hasn't, he's provided his schedule to me and I have not figured out when I can have him. Pro Hero All Might says, whoa, look at those baguette ass clothes. Frithika Frostcale says, your being part French just means you need more dough in order to loaf around on these live streams. Always. Bad Vibe says, if judge grants fees to defendants and sanctions to Vic, how is that calculated when the gavel falls? P.S. Mark, I need a roll of TP, don't squeeze in. It's calculated by the judge will determine what is reasonable. That's it. He'll make the determination. Each side will make arguments. The judge will determine what it is. Victor Phantasm says, Pop a wrecking ball. Jimbo can't get all that super chat money I sent him because of YouTube rules. Will you start a class action for the sweeties for Jim? Actually, that's a really interesting proposition. A really interesting proposition is that Jim could... Where's my chat window? Maybe I'll cover this. I should definitely do a short video on this. I'll do a short video on this. But Medicare's fans had a contract with Jim in purchasing the super chat. YouTube has said that they are not that the super chats, whatever agreement that you come up with them, all it does is provide a highlight of the chat that you send in regard that money would go to Jim, and that Jim would do something in response to that money, like say read your comment or address it. And they may not want to do it because it's probably about $250 a person. But Jim could file tortious interference, but more damaging would be the viewers filing a tortious interference claim that they had a contract with Jim. That contract was violated by YouTube's actions and prevented the completion of that contract. Very interesting. It forced a breach, right? Because you sent money to Jim with the expectation that he would do something, and Jim did not get the money. So your performance didn't occur. Maybe I'll do a video on that. It's basically how Vox Day beat Indiegogo, which is crazy. And it's basically how Uber beat, or Uber employees beat Uber. It's the same sort of theory. You get a bunch of people to bury the company in tortious interference arbitrations that they have to pay for. It's a lot of money really quick. Monica Rial's inverted nipples says, hey, Nick, I hope you are well. Your name is disgusting, and I'm great. Thank you. Bad Vibe says, say, I am surrounded by ASS holes. There you go. I'm surrounded by assholes. The affiliate says, good fan service heals all. Bad Vibe says, it was asked that you say, oh, whoa. So here you go, chat. Oh, whoa. D-Man-Dog56 says, can you do some more Second Amendment stuff? Yes, we will do more Second Amendment stuff. I'm actually working on if I can pull this off, it will be the greatest Second Amendment stream possible. Stay tuned. I can't promise anything, but I am trying. Nathan Poudrier says, hey, Nick, just joined the stream. Can I get a quick rundown? No. Bad Vibe says, what's worse, bourbon or Lemoine's filings? Lemoine's filings are way worse. Theropod Hunter says, Nick, have you ever tried Famous Grouse whiskey? I don't think so. Let's see. Freighter J says, penis. Endiku says, Funny Motion asked for roughly the GoFundMe. Is every defendant going for it? Yes. I bet Chup will grant it too. His family tree probably resembles a tumbleweed. Trump 2020 says, Vic should sue Ty Beard next for blowing the case. Suing your lawyer is a hard thing to do. Vic certainly could attempt to sue Ty Beard for blowing the case. That's something he could try to do. He would have to prove that Ty acted incompetently or maliciously. And shockingly, despite Law Twitter's brilliance, there's nothing incompetent or malicious about what happened. Ty has acted, at least in my opinion, you can disagree. At least in my opinion, Ty has always acted with Vic's best interests in mind. Ty has brought a case based on the available evidence, and if you think something was excluded that should have been included, that is probably going to be chalked up to what we would consider a tactical decision in litigation. Just because a lawyer doesn't include everything that might have won the case for them doesn't mean that they committed malpractice or some sort of negligence. It just doesn't. It doesn't mean that. That's not to say that Ty is not culpable. He might be. That would be up to the courts to decide. Vic could bring that cause of action. I think that's probably a slim chance. But I wanted to address this. I know that it's a troll question, but I wanted to address the question honestly. Vic could sue Ty. Vic could, in theory, sue me for a negligent referral. I don't think the case law would support that lawsuit, but if he did, I would suggest that there's ample evidence that the referral that I made was genuine and was 100% legitimate, and I would be able to support that as well. There's a lot of speculation from law Twitter based on facts that they don't know or don't understand, and that is nothing new. That is nothing new. That Judge Chupp happened to agree with them in principle, but importantly, not based on their actual conclusions, is fortunate for them right now. We'll see how it goes on appeals. Maybe the appeals court will agree with Chupp, and then Vic would have to consider what he wants to do next. So, Gaku says, all this time, I'm still not sure under what grounds the judge dismissed the case. Don't worry, the judge isn't either. Did I miss something, or is Judge just a chud? Judge Chupp is an idiot. He just is, frankly. Dorby says, Funimation, quote, please screw this Vic guy so hard he doesn't go after Sabat next and expose us as a pack of toxic weasels. Too late, Funny. Too late. Absolutely. Bad Vibe says, at Volney, many of us supporters demand due process. Age has nothing to do with this. Why don't you grow up a bit? Anime Collector says, now is the time for everyone who can to double their original donations. Send them a message loud and clear. That's from the Anime Collector, not from me. As I will state over and over, do not donate beyond your means. Do not donate if it would put you in any financial compromise. But every donation is fully appreciated and thanked. EEF says, why surprise they live? Why surprise they lie? Ty should be hammering this. Well, remember, Ty hasn't responded to this yet. It has 30 days. And it appears from that other response that the gloves are coming off. We'll see. Kidda says, you should explain things like, quote, Ty is not on the show when we show the GoFundMe in an affidavit, or that open you up to deposition. I don't think it would open me up to deposition. The deposition issues are the same. It's wholly inconvenient for me to travel to Texas for deposition. The information that they would get from me on deposition is readily available everywhere else. And the information that they would attempt to get from me at deposition would likely be privileged. And it would be a pointless exercise and endeavor. Talbot Link says, if in trouble and you know it, wheeze. If in trouble and you know it, wheeze, wheeze, wheeze. Kakalo Tizaru says, Nick, I've discovered something about our enemy. In Red Dead Redemption 2, there's a gang called the Lemoine gang. That means Lemoine was alive in 1899. That's why he survived the mosquito. Immortal. Curious Items Inside says, you remember that wacky deli episode of Rocco? Mayo and smooth jazz. You should do a stream with the GoFundMe and some smooth music playing for the lulz. I don't like playing music. I don't like playing anything in the background because it opens you up for a communist strike from YouTube. Bad Vibe says GFM equals get fooked mofos. CJ says Lynn's Pinker Cox hurts. Maybe they misspelled. Jay says review of materials which is discoverable. Yes. Not necessarily. DManDOG056 says, also, Nick, if you don't have Twitter anymore, how can someone get you any questions outside of the stream/Discord if they're curious about something legal-wise? Look, you can email me. My email's in the description. I can't guarantee I'll respond. I get a lot of emails. I have limited amounts of time. You can email me. That's what you can do. It sucks. You can DM my intern, and she may forward it on to me. She may not. It depends. I don't know. Bad Vibe says, can the collaborative effort in the filings hurt in appeals? Probably not. The appeals are going to ask the simple question. 3 questions. Does TCPA apply? Did the plaintiff make a prima facie showing on all of the elements of each cause of action? And then did the defense make an affirmative defense by preponderance of the evidence that would negate recovery by the plaintiff? Those 3 questions are what the appeals court is going to ask. That's it. And then depending on how they answer those questions, they'll next assess attorney's fees and sanctions as appropriate. But those are the questions they're going to ask. It's the same questions that are at the TCPA, but they're going to look at the whole record. It won't be entirely on oral argument. It will be based on the filings, and then there will be an oral argument which will be concisely limited for each party, probably to about 10 minutes of discussion, maybe 30 at most, but it's going to be limited, and they will make their case based on what was missed at the TCPA hearing. That's the important thing. They're going to say, Judge, we had this and this and this and this and this. Of course, we've made a prima facie showing. What else could a party be expected to make absent discovery? What else could we possibly show? We've shown the publication of these statements. We've alleged that they're defamatory, and we've alleged that they've caused damage, very specifically based on it. And we've alleged that they knew that they were false at the time. What more could you possibly ask for from us? To ask for anything more is to put the burden of discovery on the plaintiff without giving him discovery to work with. That's the argument. That's the argument. And they're going to enrich that argument with specific citations to where in the record each cause of action was and how it worked out. And then the appeals court will have to decide. But it'll be a very different hearing at the appeals court than it was at the district court. By nature of how the hearing is conducted itself, it will be different. So that's the hope. The hope is that that difference makes the difference, if that makes sense. Dirty Dan's has had to bust out the black label to pour one out for my man Vic. Thanks, buddy. Humble Marty says court is expensive. It is unrealistically expensive. Sakaki Onsai says, I'm not sure, Nick. Seems like the baffle them with BS technique is the only tactic that Volney and Lemon Boy seem to have. Hope appeals work. I do too. Character Holding says, hey, Nick, I've been tasked by a couple of law firms to go through a dead guy's digital life emails, iMessages, etc. Any advice? Oh, that sounds awesome. You've been tasked by a couple law firms to go through a dead guy's digital life. Emails and messages, etc. Any advice? I mean, I don't have any advice. You're probably more qualified to go through that guy's life than I am. But really interesting. I'm wondering what you need advice on. Maybe email me about it without any confidential details or anything like that. Just let me know what kind of advice you're looking for. I'm fascinated by that. Is that your job, man? That's cool. SJW Slayer Leo says, I hit mute on the remote by accident at the start of the show, then unmuted it, but still could not hear, and I thought I went deaf. Read my DMs to the intern. I'll see if I can get my intern to forward the DMs to me. Brandon Cavallero says, if Vic wins appeals and then the matters go back to Chup, can he throw them out again? It's possible on remand he could throw them out again. I don't know that the appeals court is going to remand these back to Chup. Because of the nature of how the TCPA works, I think, because if they remand it back to Chup, then they have to add to the record all of this stuff, or potentially allow the parties to add to the record again leading up to the new hearing. And it may unduly burden the parties. So what I think the appeals court will do will just say, no, this passes TCPA or it doesn't. Sorry if you've already answered this. I don't know if I've answered it or not, but I'm happy to answer it again. Whirlwinds 1499 says, first super chat. Hey, thank you. But I've been around since the Vic stuff and started. You've earned it. Hey, thanks. I really do appreciate that. Keep up all the good work and grift. All the work and grift, not good work. I don't want to misrepresent you. Got one question about your great sponsor. Which wallet is your preference? I chose first the burnt titanium. I like the look of it. It's cool. I like the fade from gray to blue. I think that's just an awesome look. But getting this guy, the carbon fiber, this is so light. But it's the most expensive wallet that they have. So I don't want to represent that this is my favorite yet. It's just really freaking light, and I like the design. I personally like the burnt titanium design a little better. I like the color. I just think that's nice. Look. But as far as weight and feel goes, this is a superior weight and feel. But with the price, if I were buying one, I'd probably buy the titanium. That's me. That's me. It's all down to personal preference. I will say that the carbon fiber is much, I mean, it's significantly lighter in the hand than even the titanium, which is weird because I took the cards out. It's definitely a heavier wallet than the carbon fiber. And that's with a band money strap rather than a metal clip. This is a lighter wallet by, we're talking fractions of an ounce here. It's not like it's heavy. But if I were going for looks alone, I like the burnt titanium, personally. That is a lot of an answer. That was a lot of answer, sorry. SJW Slayer Leo says Ollie.cosplay is a cross-dressing cosplayer on Instagram. Okay. Fluffy Side Up says, has Chuck switched sides again? I don't know if Chuck has switched sides. I don't know anything about what Chuck is doing. I've not talked to Chuck. I don't in a long time. I mean, I talked to him a long time ago, but I haven't talked to him anytime recently. Has he switched sides? I think Chuck is trying very hard to not have a side. I just personally think that Chuck, his recent statements are ill-advised. But that's me. I wish more people who know that Vic didn't do this would stand up and say, Vic didn't do this. This is bullshit. But they can't. Why? They're scared of the definitely not a conspiracy cartel of Funimation and its employees. That's why. I've been contacted by, or no, I have not been contacted. Someone I know has been contacted by a convention worker who says that Manjaw's entire testimony is BS. But they won't talk to me because they're scared of the repercussions of coming out publicly. Because it's almost like there's a giant civil conspiracy to destroy Vic and anyone opposed to him. Look at what's happening to Slatosh. Why do you think Chuck is doing this? Because Chuck is trying to preserve his own hide. That's not wrong. I think it's a bad choice because let me be clear. Because I've said, I understand why people don't want to help Vic. I understand why they're afraid to stand up. I disagree with their decision. But understand that decision. I don't think they're not going to go after you. I don't think they're not coming after anybody. I think it's a matter of time. All of you are at risk and you know it. And if you're a guy in the voice actor industry, you should be terrified at what's happened. You should be shaking in whatever flamboyant boots you're going to wear to the next convention that you own. Because you next. And the you is universal. All of you are potentially next. And what will you do when they come for you? What will you do? What will your defense be? Vic's defense was, I didn't do it. Vic's defense was to raise $250,000 of people saying this guy didn't do it. And if you don't stand up, do you think someone's going to stand up for you? I hope you're right. I hope you're right in your risk assessment. I hope you're right in your lying to cover for the Funimation employees that exist. I hope you're right. Call them good people. I hope they won't come after you. I just don't believe they won't. So good luck. Good luck. I hope it doesn't happen to you. TLJ Screwjob says, new shirt idea, God hates baguettes. Oh man, that's great. Kalinka Pavlova says, sending you small change because it sends Lemoine and company into a tizzy, and I'll never not find his attempt at getting the GoFundMe money funny. Hashtag boobies out of BoomerCon. Out at BoobyCon. Yeah, BoomerCon. Yeah, boobies out at BoomerCon. I fully support boobies out at BoomerCon. Howling Warwolf says, do you think WokeNet has successful in terminating the Terminator franchise? Oh, I hope so. It's getting terrible. It's so bad. Brandon Cavallero says, would you rather drink a gallon of Fireball or talk to Shane Holmberg for 3 hours? Gallon of Fireball would kill me, so that one. Dax Online says Funimation could care less about the fans in the fact they have yet to acknowledge DBZ 30th anniversary set that had to crowdfund $1 million for has been shipped. Okay. Angel Run 89 says, hey Nick, Manjaw is spurging out on Twitter and tagging Twitch about you. Basically her usual MO, but just thought you should know. Okay. I haven't done anything on Twitch at all to violate any term of service or rule, so she can find all of the Minecrafts in the world and get them. The Wrong Crafter says, finally got to your stream. We'll enjoy some whiskey while rewatch. Can you shill my channel? I do Minecraft and gaming vids, plus starting a new channel for anime reviews. So check out The Wrong Crafter, guys. The Wrong Crafter for Minecraft video and gaming videos, and also whatever new channel he starts out for anime reviews. So there you go. Yeah. I guess LJ Montello can report whatever she wants to Twitch about me. It's not true. And you know, as a Twitch partner, I would expect that they would have some communication with me about whatever she says, so I can refute the fact that she's whatever she's saying, and point out the fact that she's a known liar who is happy to lie about people to cause them damage. Oh, she's also a man, I'm pretty sure, right? Is she a man? I don't know. Everybody says she's not, and I unironically thought she was, like, not to be mean or anything. I thought that was a man for a long time, but apparently that's a woman. But I'm going to call her Manjaw because her jaw is very manly. So, but I don't care about that thing at all. And I call it that thing because I don't want to misgender it. That would be rude. So that thing. Anyway, well, come join me on Twitch. I think, I don't know what I'm going to play yet. Does it matter what I play on Twitch? Is that a thing that matters? I don't know if it matters to you guys. I think it might matter to the anonymous Twitch observer. But to you guys, I don't know if it matters. I have some different things. Oh, let's start this outro. I need to... Oh, come on. Let me get the settings right. Get this guy. Oh, and when I get a new computer, I'm hoping to buy one this month. If they release the Ryzen 3950X, which they're supposed to do, I hope to be purchasing a new computer, and I will do the live build of that computer on Twitch. Should be a disaster. You can watch me boomer through a computer build. But either way, again, follow me on Twitch if you want. It's all sorts of fun over there, and it's completely different than here. All right, guys, I'm going to play this outro. Oh, there it is. There's the outro. I'm going to get some food. Austin Heartless. Oh, wait, no. Asphyxiation says, in your best Tom Cruise voice, can you please say, Tom Cruise voice, can you please say, show me the money? I can't do a Tom Cruise. What even is a Tom Cruise voice? I don't even know. But he says, show me the money. Austin Heartless says, I was late, gay, and silent in the corner. Oh, man, don't be that. That's how the Blair Witch kills you. That's how the Blair Witch kills you. All right, I'm going to go grab some food. I will see you guys on Twitch in full thought mode. And I love you. I will see you tomorrow on YouTube. If you don't come over to Twitch, I will see you on YouTube tomorrow. And we will have a good show. Probably more of this. Probably Johnson and Lemoine's filings. But, recap of today. The big takeaway is that it sure looks like Vic's legal counsel is fighting back, finally, without the kid gloves. They've determined it looks like that the other party is a bunch of figs and baguettes and needs to be slapped down. So we'll see how that goes. Scruffy Kid 100 says, first super chat. Hey, thanks. How's the lawsuit against you going? I don't have a lawsuit against me. No one has sued me. So we'll see. All right, guys. Have a good night. Peace. Hashtag free Jim. Peace.
Shores of Nan to the hills of Glenlivet. There's no one who explains the thought better than Nick. So pour out a glass for the one.